मतलब मे मतलब may I be permitted to mention my that one matter, मतलब मतलब may I be permitted to mention my that one matter? My lord, may,
My lords are not audible, my lords.
yes, not audible.
Not audible.
His Lordship not audible.
Yes, my lord, I was also.
Not audible.
Whether my lord is on mute, the court officer may check it, lordship.
My lord, I have filed my affidavit of service along with an email dated
Always.
December 9, stating that the vehicle has.
Item 1, who is appearing for the respondents?
Lordship, I am Dilip Kumar Agrawal, Lordship.
Is my lord, Mr. D.K. Agarwal is appearing for the respondent.
Very
1
good.
and 2, Lordship.
लिखे नहीं. Ms. Shah, learned advocate, appearing for the petitioner, submits that she has instructions to pray for withdrawal of the writ petition, full stop, and a withdrawal of the writ petition in as much as, full stop now, in as much as the respondent number 2 has released the petitioner's goods along with the vehicle, full stop. She hands up to court a printout of an email who has sent this. Ajay Goods Carrier.
My lord, these are the contractors who have sent it.
Transporter,
But-
Lordship, most probably.
Hands up to court a copy of an email sent to her by Ajay Goods Carrier in support of her such contention, full stop. Paragraph, the respondents are represented, full stop, in view of the prayer made, comma, WPA 2310 of 2025 stands dismissed as written.
My lord, liberty may be given to proceed under section 107 before the appellate forum, my lord, for the other for other remedies, my lord.
Lordship, there it is there in the statutes.
Yeah, it's there in the
07 is
statute.
appeal provisions.
আচ্ছা ওখানে লিখে দিন উপরে যেখানে ইনস্ট্রাকশন দিয়েছেন টু উইথড্র এন্ড টু সিক লিবার্টি টু অ্যাভেল the appellate remedy under section 107 of the WBGST Act, 2017 stroke CGST Act.
Lordship, this is the CGST.
তারপরে ওই লেটার আর ইনস্ট্রাকশনটা হলো তারপরে নিচেটা লিখে দিন as prayed for, comma, WPA 2310 of 2025 stands dismissed as withdrawn with liberty to the petitioner to approach the appellate forum under section 107 of the said Act of 2017, comma, if so advised.
Lordship, it will be CGST and WBGST, Lordship.
Sir, I have passed my order. Please
Lordship.
take it on.
Lordship.
My lord, item number 2.
Service file.
Item number 2 also similar order, my lord, affidavit of service and item number 2.
Item number 2 also I am appearing, Lordship, for the respondent.
ওই 9 December date. 9 December. Same. Email date is 9 December.
My lord, item number 3, my lord, I'm appearing
If
for
apply,
I'm being led by Mr. Verma, who's appearing virtually. I believe he
My lord,
can.
I am appearing in this matter. This is a challenge to the order under section 129(3), my lords.
Another 3.
My lord, the affidavit of service.
Item number 3, I am appearing for the respondent.
Affidavit of service along with Mr.
Yes.
Verma.
My lord, my arguments on a twofold, my lords. I have challenged section 129(3) order on the premise that I was not given an effective opportunity on the date of personal hearing that was scheduled in pursuance to the show cause notice, my lord. I was there, I was made sit in the office, but I was not given any personal hearing. Am I audible, my lords?
You are audible in part. You are not completely audible. There is some network issue on your part, I think.
Now, my lords, I am audible.
Am I audible to your lordship?
Yes, to the extent you spoke, you are audible. Because you have
Now,
spoken only one line as of now.
now
Yes.
my lords, I am audible now.
Yes.
Yeah, my lord, this is a challenge to section 129(3) order. My arguments are on twofold, my lords. First, that in pursuance to the show cause notice, only 3 days were given to me to file a response. I filed a detailed response along with the tax invoice, e-way bill, including the all the invoices and the relevant documents evidencing my inward supplies from the dealers from whom I have purchased those goods, my lords. Everything was produced to the officer. On the date of personal hearing, I remained present there, but I was not given any personal hearing. So, my lords, even in the
You
impugned
were
order
present where? You were present before the authority.
before the authority, my lords, for the 3 days, my lords may have for a moment may
Then,
have the impugned
if you
order.
are present, how could you not be heard then?
My lords, the officer was not there. I was made to sit outside for all the 3 days. I have the gate passes, everything, but I was not given any personal hearing. Now, my lords, for a moment, may have the impugned order. What he records in the impugned order.
Page
Page, my lords, page 152, my lords.
152.
Yes, my lords.
152.
146 to 1. My lord, 146 to 150.
It starts with 146, but the element is at 152, my lord.
152, my lord.
152.
At pair 10 and 11, my lords may see at pair 10 on the basis of the available records with the department and the reply submitted by transporter notice number 2, the department has arrived to the following findings. 10.1, none of the notices appeared for personal hearing on the date specified, my lords.
And how do I believe, Mr. Verma, that you were present? How
My
do I
lords
believe
may
your
have
statement?
my lords may have annexure page 230.
Page
230, my lord.
231.
230.
I
Yes.
have enclosed my railway tickets, my lords, that I was in Jalpaiguri at that time only just to attend these hearings, my lords. Since 27th July, I was in Jalpaiguri till 31st. On daily basis, I went to them. I asked for the personal hearing, but I was not given any personal hearing. Page 230 and 231, my lords. My authorized representative went there. Even I have the gate pass entry. I have signed. If the respondents may be directed to produce those documents, they may produce. I have signed that entry register, my lords, also. I was not given any opportunity.
Yes, Mr. Banerjee.
Mr. Banik, my
Madam,
lord.
allegation is very grave, and first time I have come across this allegation. If your lordship allow me a week's time, I will really verify the record whether they were there or not. And if
You
they
file
are
a
not
report.
allowed, then
You file a report in the form of an affidavit.
My lord, the only difficulty is from the next week, the circuit bench will again start, and this will come under the heading of adjourn motion. So it will never be taken up.
No. I'll say it will appear as motion.
My lord,
It will appear as motion only, not adjourn motion.
I have
If
second
there is a
argument.
direction from court, it can't be difficult. A direction from court will not be overridden by the list published.
Now, my lords, I have another argument to make, my lords. My lords, page 152 and 153, my lords may have. Page 153, para 10.2.
Para 10.2.
Recently, the Supreme Court, the Honorable Supreme Court in ASP Traders, I have annexed this as Annexure P15, has categorically stated that an order under Section 129(3) that are passed by the authorities must be a speaking order.
Where are you reading, Mr. Verma? Which page?
My lord, page 153, paragraph
153. Where
10.2.
is?
No, my lords, I am specifying the law, what the Supreme Court has laid down the law. the Supreme Court has categorically stated that an order under section 129(3), that is MOB 09, must be a speaking order. It must spell out the independent evaluation of the respondents of the proper officer as to how my case falls under section 129(1) and where there is an intention to evade tax. My lords may have their findings now.
Yes.
Prior 10.1, none of these notices appeared for personal hearing on the date specified in the notice in GST MOB 07 dated 24/7/2025. Further, the consignor JJ Traders, that is the petitioner here in my lords, has submitted a reply on 28/7/2025, in which they have contended that the weight of goods as mentioned in the invoice is correct. However, they have not provided any documentary evidences like weightmanship before and after loading of document. They could not provide any clarification how the weighment of good done by the department is not correct. Now, my lords may see the next paragraph, how they have dealt with all my submissions, my invoices and everything. Prior 10.2, my lords. Further, they have submitted various documents like copy of bank statement of Axis Bank and Punjab and Sindh Bank, registration certificate, monthly stock summary for financial year 24-25 and 25-26 up to 28 July 2025. That is the date of detention, my lords. Random purchase invoices, etc. However, the documents submitted are haphazardous in manner. The invoices submitted are not enough to prove the genuineness of procurement of goods.
I'm extremely sorry. I'm sorry, Mr. Verma. My lord, I tender my unconditional apology, Lordship. I interjected in the matter. Lordship, I am not in this matter. I am in Calcutta, item number 3. So I wrongly appeared in this matter. I tender my unconditional apology.
My lord,
I
Mr.
think
Banik
Mr.
is appearing
Agarwal,
in this matter. Mr. Ratan Banik is appearing in this matter, my lord.
I am extremely sorry.
I don't know why.
I'm
Who
extremely
is appearing for the respondents in this matter then?
Mr. Ratan Banik is been appointed to appear in this matter. Earlier occasion also he has appeared.
If it is a CGST matter, then Lordship, I can inform the concerned authority.
It's not a CGST matter.
My lord, earlier occasion Mr. Ratan Banik has appeared in this matter, and I know that his name is also reflected. He's
Serve a notice on him.
My lord, I have already served.
Come tomorrow, because today in their absence I will not be able to pass any order. Liken impact order. The petitioner assails an order dated July 31, 2025, passed under section 129 within bracket 1 or 2.
1.
My lords, he has passed under both 129(1)(a) as
section 129 of the WBGST Act, 2017 / CGST Act, 2017. Thereby, page 153 is the order.
Yes, my lord.
146 onwards, my lord, the order starts.
No, the operative portion.
Operative portion is on 152.
154.
152 and 153.
153. Paragraph number 10, 10.1 and 10.2.
150 page number.
Thereby imposing penalty on the petitioner. Imposing penalty on the petitioner. Full stop. Paragraph. Mr. Verma, learned advocate appearing for the petitioner, submits that the order impugned has been passed in total violation of principles of natural justice. Full stop. It has been further contended that although the petitioner's representative was present before the adjudicating authority, yet no opportunity of hearing was afforded to the petitioner's representative, and the order was passed without and the order was thus passed without
Am I audible, my
any
lords?
personal hearing.
Mr. Ratan Banik is there.
Mr.
Am I audible, my lords?
Yes, you are audible.
My lord, I am appearing in this matter on behalf of CGST authorities, my lords.
Yes, CGST is all right, but this matter is against SGSTs.
No, my lord, this is against CGST only.
This matter is against CGST.
Yes, my lord.
CGST only, but Mr. Ratan Banik has been allotted, Mr. Agarwal.
Yes, Mr. Agarwal, what is your response to this? No, he is gone.
My lord, he doesn't have the brief.
My lords, my lords, am I audible now, my lords?
Yes, you are audible. What is your response? He says that he was present there, but he was not heard.
No, my lords, may kindly go through the read itself in the page.
Very difficult like this. लिखो, you लिख लेंगे.
Hello, my lords, I got disconnected due to some technical error.
Yes.
My lords may kindly take their own communication dated 31st of July, my lords, in email ID, email dated
Page
55, my lords. In the last email,
Page 55, yes, last email.
that is dated 31st of July.
Yes.
They have not alleged that they, after 29th, the 31st of July comes, they have never alleged that they were present or they
But
did not,
why
they
will-
were not afforded personal
My lord,
hearing.
why will they annex that in mail that I am
This is
present?
the first
They
time
can only
allegation
annex the
is
supporting documents.
No, but how will
Why
this
would they?
prove that they were not present? This they have given tax invoice, e-way bill,
To
all
give
these
the
things they have
documents
given.
before the authority.
When was the
They-
hearing taken? When was the hearing taken?
My lord, on
20
day,
I mean scheduled, not taken.
29th of July, my lords.
Mr. Verma, but if you are present and you were not here given a hearing, would you not record a contemporaneous objection to
no,
this?
my lord, what happened was I came on 27th only. On the mail, I gave him the detailed reply, everything. On 28th, I went there. I specifically stated in my writ petition also.
No,
I
you
went-
may have stated in your writ petition, but if you are not given a hearing,
Yes, my lord.
and despite your presence there, then will it not be reasonable for any person of normal prudence to immediately record an objection to that effect? If
My lord,
if you are availing of mail facilities, you are tech savvy, then in that case this is very easy. You will
My lord,
definitely
what-
record your objection to that. That see, I was present there. You have not given me a hearing.
My lord,
This is
what
quite
hap-
normal.
My lord, what happened was when I went there, I sat there. The officer asked me to sit outside. I sit outside.
Very
I
well.
was
That all I have understood. You were
every day,
asked
my
to
lord,
sit
they were
outside.
doing the same thing. On 29th, they did
Very
the
well. On that day, you did not do. On the next day, on the second day, on the third day, you have not recorded any contemporaneous objection. How will the writ court now, if they come up with an affidavit saying that no, you did not go there? What will be there? Even if
My
you
lord,
have gone there and you have sat outside, you did not enter the room. How will all these things be proved by a writ before a writ court on the basis of affidavit evidence?
My lord, I have signed the gate pass. At the time of entering into that office, I have to sign a register specifying all my details. At what time I have come, at what time I have left. I signed that. They can produce that. They can produce that, my
That
lord.
can be produced before the appellate authority also. Why writ court?
Because in that case, I let my goods be released. I have no objection if it goes, but let my goods be released under 129 1A. That's why
Like
I
my
all the
like my
documents.
other matters, Mali, if the goods are released, then I can approach the appellate
Suppose
court.
the
But the
appellant, the goods has to
petitioners,
be released. They are not even releasing the goods, despite I have given the representation various times. My lords,
Why
I
is not releasing, Mr. Agarwal? What is your problem in releasing the goods?
My lords, we have no problem in releasing the goods if he pays the penalty as is specified in MOB 9 order. That he is claiming to pay the penalty and the taxes liability as per 129 1A, whereas he is liable under section 121 B. We are asking 129 1A and B. This is the only confusion thereof, my lords.
my lord, it's a very undisputed law, already being settled by every high court. a consignor's name whose name appears in the text invoice and the e-way bill which was produced at the time of interception of the vehicle, that person will remains the owner of the goods, the deemed owner. There is a CBIC circular. My lord, for a moment we have page 187. 187. Page 183, my lords. This is it starts with page 183.
183.
This is issued by their own department, this circular.
Yes.
Clarification on certain issues. Various representations has been received seeking clarification of certain issues under the GST law in order to clarify the issue and ensure uniformity of implementation across field formation. The board, in exercise of the powers conferred under section 168 of the CGST Act, hereby clarifies the issues as follows. Now, my lords may have page 187, which pertains the relevant. It's a very undisputed fact, subsequently sanctified by the division bench of this court. I'll take my lords to that only. Page 187, CL number 6. My lords have that?
Yes.
Who will be considered as the owner of goods for the purpose of section 129. It is hereby clarified that if the invoice or any other specified document is accompanying the consignment of goods, then either the consignor or the consignee should be deemed to be the owner of the goods. If the invoice or any other specified documents are not accompanied accompanying the consignment of goods, then in such cases the proper officer should determine. So, my lord, he has no discretion. Once at the time of interception.
Yes, Mr. Agarwal. Now, on the basis of
My
this,
lords may kindly take to
on the
page
basis of this,
148 of his.
take your money and release the goods.
That is the
My
thing.
lords, my lords, if
That
he
is
pays,
the
my lords may kindly take the page 148 of this writ petition, my lords.
$148. Yes.
My lords, para 3. There is discrepancy in the para 3A. The quantity of as per invoice is this 17500 kgs and weighment is 18800 kg. Excess of
148.
kgs, my lords.
148, my lord, 148.
148. Yes.
My lords. In para 3 they have noted the discrepancy in the material, whereas in 149, the concluding page, they have already mentioned that they are not able to establish the ownership of their goods. We are only claiming they have already been asked to produce the relevant purchase invoices and other details.
That I have purchased, they have not considered.
Well, that we have sent via mail.
They have an appellate authority, my lords.
Well, let the goods be released, then we can approach the appellate authority.
Mr. Verma, this notification is not about 129.
It's about 129 only, my lords. It's about 129. No. It has been subsequently referred by the division bench. My lords may have
Show me that judgment. Show me that judgment of the
yes,
honorable.
May have page 200
because the subject does not pertain to that.
No, my lord, it pertains to that.
I'll refer the 142 too.
My lords, my case is only on 129, not on 142 too, my lords. It's on 129.
That is why this notification pertains to that only. It's not about 129.
My lords,
this
takes to page 152 and 153, my lords.
My lords, this notification.
Mr. Agarwal, please wait. Speak when your turn comes. Yes.
My lord, this circular is under section 168A, which entitles
that I understand, Mr. Verma. Please see the subject on which the circular has been issued.
Yes, my lord.
Read the subject. Please read the subject.
Yes, my lord. Clarification of certain issues, sale by government department to unregistered persons.
This is one. Next. Leviability of penalty under
section 7311.
Yes,
Rate
this is
of
to
rate of tax in case of credit notes issued under 142
this is 3.
applicability of notification number 50 of 2018
This
Central
is 4.
valuation methodology in case of TCS under Income Tax Act
This is
definition
5.
of honor. No, my lord, the definition of honor of goods related to GST.
This is for what purpose?
No, my
Valuation
lord.
methodology in case of TCS, income tax, and definition of goods.
No,
It is for
ownership
that.
is, my lord, under the GST Act, ownership is only under 129.
You show me the division bench judgment on this. On your interpretation, I will not be satisfied.
My
Show me
lords
where
may have
division bench has
page
interpreted this.
my lords may have page 215. This is a honorable Chief
Annexure
Justice.
321.
215, yes.
Yes, my lords. It starts with, my lords, 215. The similar allegation that is there in my case also is in this, that a driver's statement was being taken. My lords may have page 220. The relevant portion, I'm taking my lords to that relevant portion only. The honorable division bench categorically specified this.
Yes, page 220.
Paragraph number 13, it starts with, my lords, I'll read it. It is not in dispute that the vehicle on the date when it was intercepted and the goods were detained, the documents to be carried as stipulated under Rule 138A, 1A and B were carried by the transporter, who is the second appellant and the writ petitioner. Exactly my case. Therefore, on the date when the vehicle was intercepted and goods were detained, there was no contravention of section 68 read with 138A. If my lords, for your convenience, I'll take it to my lords to Rule 138A, why it is important.
138A, you need not take me to.
Yes.
You show me how your facts match with paragraph 30.
Yes, my lords. I'll just read out, my lords. In such be the position, section 129 would have no application to the facts and circumstances of this case. Apart from that, department has not able to establish that there was any intention to evade payment of tax by the appellant or the petition, which is a prerequisite to invoke the powers of powers under section 129 of the Act. Now, my lords may have this circular. The circular issued by CBIC dated 31st December 2018 is of relevance. The circular has clarified certain issues in CL number 6 of the circular. This is the same, my lords, the same circular. The issue is who will be considered as the owner of the goods for the purpose of section 129(1) of the CGST. It was clarified that if the invoice or any other specified document is accompanying the consignment of goods, then either the consignor or the consignee should deem to be the owner. In the
and how does your fact? I have read it. How do the facts of your case match with paragraph 13?
My lords may have MOV 07 page 48. They themselves are recording this fact that at the time of interception they found the tax invoice in the e-way bill.
Page 48.
The first paragraph, my lords, below MOV 07.
Yeah,
The goods conveyance being registration number TN45BJ7583 was intercepted by the inspector, that is the second respondent, on 11/7/2000 at about 2 a.m. on this and this place. On being asked, the driver of the conveyance produced the copy of invoice LA number this and this issued by the consignor JJ Traders, which is a petitioner in, my lords. To the consignors, Soyana Supai Central, house number this and this, and consignment dated this and this. They themselves are recording that the tax invoice that is produced contains my name as the consignor.
No, but they find discrepancy in the payment also.
No, my lord, payment is a separate thing. My lord, my lord, for the payment, they can impose penalty, but they can only impose penalty under 129(1)(a). That is has been sanctified by the division bench, that they can impose penalty. There is no such reason. But as far as the ownership, it is a very undisputed fact, my lords, that under 129.
Yes, Mr. Agarwal, you release the goods in terms of this division bench judgment, and they will prefer appeal against the order upon taking the.
My lords, kindly text to page 153, my lords.
Yes, page 153.
152 and 153. Para 10.1 and 10.2, my lords.
I've seen that.
10.2, they have not able to establish their ownership of the goods through how they have procured
that is on merits. He will challenge the order. Yes. But so far as this is concerned, since the invoices bear their name, in terms of the division bench, I am bound by that.
Yes, madam.
Yes, ma'am.
Didi लिखें the petitioner ওই উপরে তো লিখেছেন তো আছে নিচে লিখুন মিস্টার ভার্মা ওইটা ওনার সাবমিশনটাও লেখা আছে যেটা লেখাই আছে কি লিখলেন শেষে
But my lords, in division bench order, there is some difference, my lords, because in there's clearly there was no discrepancy in the material, and they were already matlab,
It
my
has
lords,
nothing to do with it, my lord. It has nothing to do.
Differentiated, my lords.
It has
to
nothing to do.
differentiate that then differentiate how it can be differentiated
My lords, in this matter, in page 153 in the MOV 7, MOV 9, we have already specified that they were not able to produce the bank statement and other monthly stock summary, and which they have submitted are not.
Mr. Agarwal, I am not setting aside the adjudication order. I am only passing an interim order for you to release the goods in term by treating them as owners in terms of section 129. The ultimate finding will be taken by the appellate authority. This is only interim in nature. This finding will be ultimately subject to the finding by the appellate authority in the appellate proceedings under 107.
Yes, my lord.
The adjudication order will stand.
But my lords, they are not able to prove their ownership only in terms of
Ownership, I do not need to.
He's
Then
not
my lord,
required. The division bench says that in terms of your own circular, this is how you are to assess ownership. Who is the owner?
my lord's KP Weigel's judgment of the Honorable Apex Court, if my lords want, I'll place it. That categorically states that these are binding on the department. They cannot take any contrary view to it. That is what the division bench has also held in this case.
grateful, my lords. My lords may grant 1 day time, my lord, to get further instruction from my lords.
Very well. Let him come back tomorrow.
My lord, this
My lord,
matter has been
this is
shifting
one
from
day
this
instruction,
side
my
to
lord.
that
One
side,
day,
and
my
they have been
Tomorrow,
taking
tomorrow.
time whenever they are losing their time.
Tomorrow. Mr.
my lord,
Agarwal,
this
please
is the
come
third
tomorrow.
time that they are losing. The Honorable Court has
My lords,
taken
actually,
this
the
step
senior
and they
counsel
are
is
taking
also
the
not.
later
I
time.
was just.
Then why were he was arguing, my lord, till date?
I
Now
am
saying that
present, my
the
lord.
senior counsel is there.
Very well. Let him come prepared. If he wants to come prepared, I cannot brush him aside. Come
One
tomorrow.
day, my lord. Grateful, my lords.
Mr. Agarwal.
আগেরটা যেটা লিখেছেন লিখে নিন তারপরে লিখুন মিস্টার আগরওয়াল learned advocate appearing for the respondent CGST authorities seeks a day's accommodation to get better prepared, full stop. List this matter for further consideration tomorrow. কালকের দিন।
Grateful, my lords.
Grateful, my lord.
Grateful, my lords.
But I think, my lord, I need not open my mouth. Your
Yes.
lordship has gone through the circular as well as the, my lord,
Yes,
the
Mr.
division bench
Chakraborty.
judgment. And my lord, in my case, my lord, one step better. Why? The quantity is undisputed and quality is undisputed. Here, my lord, there was a dispute regarding quality and quantity that is undisputed.
But once my lord complete his submission has.
What about the circular?
That circular is not applicable. Here
Why?
the owner has come up. And there is a specific finding that he is not the owner. Here the owner has come up. My lord, question was driver. My lord, who was given the documents, whether here
No. If how the owner is to be, who is the owner, that is to be decided on the basis of the circular. The circular has given the guidelines.
well, if you respect the word guidelines always is not a directive.
It is binding on you.
Well,
Binding on you always. It can only not be binding if there is a statute law which it contravenes. Otherwise, it's binding.
Like on the statute, well, can you consider this? I have
If you
counted
can
that-
see that the earlier version of the Honorable Supreme Court in Varghese was it is binding. It has been clarified later. The later clarification is that it is binding on you unless there is a statute which supersedes it, and that binds you, and it speaks in a contrary tone. It is only then that you can, if you can today show me a statute which says that this is how it is to be worked out.
May just one by may I tell? Well, the case made out by us, the case made out, because we have issued a show cause notice, right?
Not show cause order,
Oh,
penalty order.
by a show cause notice, whatever the proceedings, whatever, what. But I said the proceedings started by a show cause. So there were two invoices. Today the Damru has come before my lord, who is the subsequent owner who has purchased. My lord, kindly see the two invoices. But where there is allegation of fraud, whether my lord would consider that circular to be binding. It's a case of fraud.
Yes, circular is always
But
binding,
I'll
whether
tell
fraud
you
or
why.
not.
There is a reason.
Circular is
Lord,
always
kindly
binding
to
because the
page-
circular is
My lord, kindly come to page 25.
25.
My lord, so my lord, this is the invoice. My lord, Damru is the consigner.
Yes.
Dispatched, it's an information given that
Yes.
he is starting from Assam. My lord, right hand side,
दीदी
generated date.
আগের ফাইলটা একটু দিন তো সার্কুলারটা সামনে খুলে রাখো You don't have a copy of the circular, even I don't have.
Let my friend place his case, but then I shall give a short reply. Although I am binding by the circular and the division bench, which meant the earlier matter have already been.
And I'll also rely on deputation.
Yes.
Page 25, kindly see.
Page 25, yes.
Generated date 10th November 8:28 p.m.
Yes.
Now, my lord, this is the prior in time invoice. Well, they have also annexed it, but which is not legible, so I am giving a copy. But I would kindly see this invoice. But this is URP Assam, consigner and to Damu. URP to Damu. My lord, when it was generated? Again, 7:52 p.m. And this is generated 8:28 p.m. And how much this distance to be qualified? 266 kilometers. 266 minutes, and the validity was for 2 days. And this is online, but they have uploaded. We have come to from their uploading, we have come to them. And this is one of the contention. How did you get the goods? If the origin position is 10th November at 8:28 p.m. and you say you have original is at 7:52 p.m. How is it possible? The entire transaction has been questioned, my lord. This is not a question of, my lord, who is the owner. The entire transaction. Now, my lord, kindly see the allegations. Specific allegations as regard to this show cause. There is no answer to it. I'll show that.
No,
now,
what is the series of transactions?
Well,
First the consignment is given by URP to Damru and then from Damru to Navkar.
Yes, yes. Well, that is
This is the sequence.
Just chain I am just giving. My lord, your lordship's query, that day I did not have the proper instruction, today I have. Lord, kindly start with the case. Lord, when the tier weight was taken. Lord, I said the vehicle was coming from Bihar because it's a Bihar registered vehicle. Lord, kindly the same vehicle. Your lordship will find this.
No, do you have an averment, Mr. Majumdar, in the writ petition that it was coming from, because registration may be there of any state,
Bihar,
but I can.
It has to be. What I am
on
saying,
that day, whether it was coming from Bihar or not is important.
It is correct, but your lordship will find both the invoice, the truck number is same. So we have engaged the truck for the transportation. There is no dispute about it.
No, where is that averment? That averment has to be there in the writ petition, because by number, though, I can have a number of Bihar over here also and can use it. But that will not mean that.
Leave it, Millard. Then leave it, Millard. When the Airways was taken, Airways one was taken on 10th of November at 9:27.
Pages.
Yes. Your lordship will find page 28, which is their allegation in show cause.
28.
Yes.
28.
Yes, your lordship will find last para. On the basis of radio frequency identification, although our High Court said it is not valid.
Last para, yes.
Yes, your lordship will find it is observed, well, I got it, 5 line from the bottom, it is observed from the RFID tracking data.
Yes.
The instant conveyance was already entered West Bengal from Assam. No, not this one, just Lord, just for few lines before. It is observed that the vehicle was physically present and so on, so on, so on. Oh, next page. Well, I'm sorry, next page.
29.
Yes. Third line, it is observed that the tear weight of the conveyance was measured on 10
Third line,
Third line, on the right hand side.
it is observed. Yes.
Yes. The tear weight of the conveyance was measured on 10/11/2025 at 9:27 am, and the gross weight after loading of the goods taken on 11/11/2024 at 4:20 am. Well, kindly mark this. So 10th, the tear weight of the vehicle was taken
Yes.
at 9:27 am, and the gross weight taken was next day, that is 11/11/2025 at 4:25 am. Now, Millard, kindly come to the sequence. Now, from the places where the tear weight is taken to Dhubri, where the goods was uploaded, your lordship can find out in the Google itself. Millard, it is taking, Millard, 129 kilometers. It would hardly take 3.5 hours to 4 hours.
And this place is where the stair weight was taken?
This is in Jalpaiguri.
This is in Dhubri?
No, Dhubri.
Yes.
Dhubri and Dhubri. Dhubri is in Assam, Millard.
So this place is in Jalpaiguri. This
Jalpaiguri,
is
where the tear weight was taken, and Dhubri, Millard, only to show our bona fide, Millard, this thing has been done. Otherwise, Millard, there is no statute, Millard, the statutory requirement to take the tear weight and gross weight. There is no statutory requirement. Last day also your lordship has pointed out that. Now, Millard,
so from Dhubri it goes to
Dhubri, Assam, to load these goods, where I have purchased these goods. What are the tax invoice? Now, kindly take this document. Although I have annexed it, but I think it's not legible. But I have purchased these goods.
This is what page? Which page of the writ petition is this?
We have annexed the EUA bill, but this document will, as per the statutory mandate, this has to be uploaded where I have purchased. We have uploaded it. This is the statutory document. Invoices.
It must be a part of the writ petition also.
No, it is not part of it.
Well, they have already relied on it. They have already relied on it in their order.
Very well. It becomes difficult because if it is not a part of the writ petition, how will I look into it?
Then your lordship has to go through by the EUA bill which has been generated.
Yes,
But
yes,
can you keep it aside? Admittedly, I have purchased it. This is the tax invoice which says that I have purchased this material on 10th November from Dhubri, Assam. Well, got it. Can you see? 10th November, loading point, Dhubri, Assam. Guwahati. To Guwahati. Well, on basis of this tax invoice, the EUA bill was generated. Where, below, as soon as I purchase the material, but kindly see the quality and quantity also. The same quality is a quantity. But quantity, your lordship will find 34,650 kgs and rate dried Erica nut, the same blood the material, your lordship got it, left hand side, weight, and see the rate also. It is very important why I am saying so. But kindly see the rate, in what rate I have purchased. 110 per kg. You not got it?
Very well. These will be shown in the EUA bill also. Show me from the EUA bill.
Now, my lord, your lordship will find the EUA bill. Now, this, as soon as I purchase it, but I shall take it to my place of business, that is in Guwahati. From Dhubri to Guwahati, it's almost 266 kilometers. But got it? So, if I
so at the time of purchasing this,
yes,
an EUA bill must have been generated.
Yes, this
where
is
that?
Bill.
Where is
the EUA bill?
This is the EUA bill.
That is
the one which you handed up. No,
yes,
you have handed up the invoice, not
yes,
the
invoice supporting of the EUA bill.
But I had handed over the EUA bill.
Your lordship, can I have a copy of this? If your lordship can take it also. Now,
yes, I have a copy of the EUA.
Yes. Bill. Now, your lordship, see, it was dispatched from Dhubri. I purchased it from Dhubri. Got it, left hand side.
Yes.
And this is right hand side. Says Sundarigapa is my official address. My GST, my lord, the GST number is given, the Damru Enterprise, the petitioner before is also there. So I have purchased the material from the place called Dhubri, and it was supposed to go to my place, which is Guwahati, which is 266 kilometers. But what happens in this kind of business, that once I procreate the goods, immediately the buyer is ready. Well, got it. The buyer is ready. So because I want to pay the tax, so I have generated another UA bill, because the Dhubri is the bordering area of Assam. Again, if I go back to Guwahati and transport it to Delhi, it is already double the way. I have to go back to Guwahati again, transport. It is like this. Suppose I have a business establishment in Durgapur. I have purchased the material from Calcutta. Kindly, this is the practical picture. I purchased something from Calcutta. Material has to say to Bhubaneswar. So, my lord, the material, instead of taking it to again Durgapur, from Kolkata, my lord, I have given it to Bhubaneswar. My lord, got it? And it was not taking a different route. That is the reason, my lord, this has been done. Now see my UA bill on which, my lord, I have, my lord, transporting the goods. Page 25. And kindly see the quality and quantity also. And amount. My lord, kindly turn to page 25 once.
Yes.
My lord, kindly see. This is my GSTN number, Damru Enterprise, Shodgop is my official registered address. But as soon as I purchase the material, it belongs to me. As soon as I purchase the material, so it belongs to me. So from when I was generating this UA bill, after purchase, not before purchase, well, kindly see the time also. This was purchased at 7:25 evening. And this UA bill was generated after 45 minutes. That is 8:25.
These documents you should bring by way of an affidavit, because these are the important documents. You are relying on them.
My lord, got it. Now, my lord, kindly see my intention also, page 24. Your lordship has seen the dried erica nut which I have purchased, a sum of rupees 34, the quality is 34 kg, 650 gram. My lord, got it. Now see page 24, what is the, my lord, the quality and quantity. And rate, your lordship will find 126, because when I am selling someone, obviously I'll take my margin. So 16 rupees per kg I have taken my margin. And on that, my lord, I have paid tax, 5% tax to them. My lord, got it. Now, my lord, what is important is the act itself. My lord, kindly see 129. My lord, yesterday night, I was reading 129. Whether, my lord, they have any jurisdiction to, my lord, for determination of goods, who is the owner or not. Kindly see the language of the act, the essence of the act. And, my lord, before that, my lord, kindly turn to page 32. Your lordship has gone through the circular. The tax invoice and UA bill, if it contains, it belongs to the petition, the person will be the owner of the goods. Kindly see in my reply what I have given. Page 32. Respected sir, I, the authorized representative of the owner of the goods transporting the vehicle number so and so, respectfully submit the following reply in response to the stoker's notice issued in so and so. Now see, not the nature of goods and orders, the document which I have annexed. This is in terms of the circular, your lordship got it? And all documents were produced before the inspecting officer at the time of inspection. Now, my lord, kindly come to the act once, my lord.
Yes.
Notwithstanding anything contained in this act, where any persons transport any goods or stores any goods while they are on transit in contravention provision of this act. Kindly pause it for a moment. My case, that I have not done anything which is the contravention of the act. I have not done anything. It is, my lord, the authenticated UA bill, the authenticated tax invoice, everything was accompanying with the goods. Admittedly, in my show cause notice I have given. Now, my lord, read further. My lord, kindly read further. or the rules made thereunder, all the goods and conveyance used as the means of transport carrying the goods and documents relating to such goods and the conveyance shall be liable to detention or seizure, or after detention on seizure shall be released. This is an interim measure. Shall be released. The word is shall. One, on payment of penalty equal to 200% of the tax payable on such goods. The category of goods falls in it. Because I am not in an exempted category. Now, kindly see, the language is very, very important. Where the owner of the goods comes forward for payment of such penalty. So we are coming forward to pay the penalty. Your lordship will, and the second, the clause B, this is where the owner is not coming forward for the payment. And your lordship will not find anything in terms of 129 that the authority can decide who is the owner or not. And that has been further clarified in 2018 notification. So, this is for the interim measure. I am showing my UA and tax invoices saying that these goods belongs to me. You please return to me and I am ready to pay the penalty. My case here before your lordships today, I have not acted in contravention of the act. And that is the reason I shall prefer an appeal in terms of 129(1)(a) where the order is being passed. Appeal will be filed by me in terms of when the order has been passed in terms of 129(1)(a). Because I am saying I have not done anything which is contravention of the act.
Yes, Mr. Chakraborty.
Well, it's sum and substance of the argument is the whatever is there in the eBay bill can be incorrect. Whatever is there, the sum and substance. I have told that origin starting point is Assam. It can be anywhere else. But then there is no requirement of giving a UA bill. When I give a UA bill, I certify that the information are true and correct. Then what happens? Malad would kindly come to Malad. Everything is happening on tape. Everything. Kindly come to 25. What I was arguing, Malad. So, Malad, this e-way bill is generated at 8:28 p.m. Let us be clear on this. It is their information and they have to show this information is correct or not. It is their burden. Burden is on them. 8:28. And just the previous transaction, the e-way bill was generated at 7:52 p.m. Well, upper portion generated 7:52 p.m. Top generated date 10 same date.
This document is page 23A. Should be, yes.
So I could not read it for that much. I could not read it.
This is 23A.
So, the difference is about 34 minutes.
So according to you, when this e-way bill at page 25 was generated, the goods were not there at this place.
Today, I'll show the law. E-way bill is given at the before the conveyance starts. Why? They have to upload, they have to give the information to the authorities that this transaction has started. If today, if our allegation is an interstate transaction where the owner is not coming out, original owner. That is the specific. I'll show Malad. Kindly give me 5 minutes. Now, Malad, the difference at distance, that 23A is 266 kilometers.
Yes, that we have seen.
66 kilometers, Malad, that is. Now, Malad, kindly, our allegation one by one, kindly come to page 28. But first, Malad, whether these are all factual disputes. It is near to the border area.
Mr. Chakraborty, I am again repeating this 129(1)A, B, C. These are all of interim nature.
Yes.
Ultimate order is passed under subsection 3, 129(3). That order will be assailable before the appellate
This
authority.
order is also acceptable.
Very well, it is. It is assailable. But if he wants to get the goods released, and there is a circular which shows that you will treat him as the owner for the purpose of section 129(1. That is the specific circular.
Yes,
The
yes.
language is
Well,
who will
very
be
happy
considered
to
as
have
the
the
owner,
circular sent me. But today, madam,
who will be
madam,
considered
this is
as
not a
the
case,
owner
madam.
for the purposes of section 129(1.
This is-
Now, if for the Mr. Chakraborty, let me articulate once so that you can be you will be in a better position to answer. Who will be considered as the owner of the goods for the purposes of section 129(1? 129(1 is the procedure contemplated to facilitate release of goods upon either the owner or a person other than the owner coming. If the owner comes, then in that case, your business would be to see that you can impose penalty in terms of section 129(1)(a). If a person other than the owner comes, it will be 50% whatever it is in terms of 1b. How would you decide? This confusion will be there. So at this stage, the decision will be in accordance with this. Now, if I observe that this is not going to bind the appellate authority in ultimate hearing, because this penalty is not being, I'm not disturbing the proper authority's order under section subsection 3.
I understand. Bow down. Today, my lord, with deepest respect, with utmost respect, this is an absolutely case of fraud, and my lord would not exercise his discretion under Article 226. I am going to that extent for now. This is a case absolute fraud. Absolute fraud. My lord, kindly see vis-a-vis our allegations and his reply. My lord, kindly come to my so-called MOB 07 at page 20.
You will not let me go an easy path. Page?
Well, 28.
Page 28.
Last paragraph. I do not fight to on
No, it's your business, definitely. Yes.
Last paragraph. As per the document produced by the driver of the conveyance, the goods are being supplied and dispatched from the state of Assam as the declared purported consignor is so and so, the petitioner. And the place of dispatch is declared as so and so Assam on Atom. On verification of RFID data of the intercepted vehicle, it is observed that the vehicle was not physically present at Sundargarh, Assam anytime near the time of generation of the e-way bill and issuance of tax invoice produced. The e-way bill bearing numbers was found to be generated on 10th November 2025 at 8:28 p.m. where as per RFDI at the time of generation the vehicle was placed in Rani Kali Bazaar, Talpada, West Bengal. This is the specific finding. At no point of time, for the previous transaction or the subsequent transaction, it was in Assam. This was always in West Bengal. And 10th November. Now, I'm just holding here. Kindly see the law. Kindly see Rule 138 and 138A. Kindly see. (138).
138.
Yes. Every registered person who causes movement of goods of consignment value exceeding 50,000 rupees in relation to the supply or for reasons other than supply or due to inward supply from an unregistered person shall before commencement of movement furnish information relating to the said goods as specified in Part A of Form EWB electronically on the common portal along with such information as may be required on the portal, common portal, and a unique number will be generated on the said portal. The transaction started, he says, I am in Assam. Before the commencement, he says, and we find it is in West Bengal. Now 138A, my lord. Before the commencement, it is not after, my lord. There are certain relaxation. I'm not going into that because that is not the case here. 138A. The person in charge of a conveyance shall carry the invoice or bill of supply or delivery challan as the case may be, and a copy of the e-way bill in physical form or the e-way bill number in electronic form or mapped to a radio frequency identification through which we have identified the vehicle was not in Assam at any point of time. The device embedded onto the conveyance in such a manner as may be notified by the commission. So, these are the information which is required statutory manner. Today, what my learned friend is saying, with deepest respect, are contrary. He is deliberately giving wrong information to the authorities. If 7:52 is the first, 7:38, whatever the time, at 7 p.m. he has got a first e-way bill, then the movement the goods could not have started from there. And they could not have been on 10th November, it could not have been on Jalpaiguri. That is the specific allegations. So that is the specific allegation. Now, Malad, kindly go forward with the allegations. Now, kindly see. And has further crossed Rango Bazar Plaza, West Bengal on 10th November 2025 at 8:25 a.m. From 10th November 8 a.m. to 11th November 4:45, the instant vehicle was located between Rongli Bazna Toll Plaza, West Bengal and Astudanga Toll Plaza, West Bengal. And it appears that instant inspected goods has been loaded in the conveyance at some undisclosed place located between the above mentioned toll plaza, and accordingly, the produced documents were generated and handed over to the driver. At the time of interception, the driver of the conveyance also produced a weighmanship slip issued by so and so, wherein it is stated that the net weight of the goods loaded in the conveyance is so and so kg. It is observed that the tare weight of the conveyance was measured on 10th November 2025 at 9:27 a.m. and the gross weight after loading of the good is taken at 11/11/2025. So, the measurement of the goods only on 11. So, how did this 2-year was generated? On what basis? The quantity, how the quantification came to know? If 11th is the date, in the both the invoices, e-bill all written, the quantification is there. How could they ascertain the quantification?
But there is no dispute as regards quantification. The weight is always same.
Information.
Question is intent to evade also. Intent to evade also, but there is no intention. He has paid taxes.
But the question is, he is trying to say it's an interstate sale. If it is everything is West Bengal, it would be an interstate sale. There's a distinction, my lord, with deepest respect. Now, kindly come to me. Further,
distinction is only which state will get the taxes.
Yes, that is more
which
vital,
state will get the taxes.
Well, that is more vital. Well. Now, kindly come to the next page. 30, Roman 3.
But that you will adjudicate at the appellate stage.
The question is, well, today, there cannot be any case made out to be a discretion to be exercised. But I will show how the.
Why not? In terms of the notification, if who is the goods is to be ascertained.
I know I'm disturbing this code. This is a heavy. I know determination is heavy. I know. Roman 3. On verification of e-way bill generated on the vehicle number so and so in the e-way bill portal, it is observed that prior to e-way bill produced, another e-way bill was found generated bearing number so and so dated 10 November 2025 at 7:50, generated by Damru Enterprise Assam on tax invoice bearing number dated at wherein the transaction type is declared as regular and the declared consignor is Yoruba and the consignee is Damru Assam, and it is declared that the goods are being dispatched from Dhubri, Guwahati, Assam, so and is being shipped to shed number so and so. The goods supplied is declared as good covered by HSN quantity is atom. From the generated event, it appears the supplier of the goods generated consumed the actual supply of the goods from some place in West Bengal lying between Rongoli Bazaar Toll Plaza and so and Ashok. You know why? Well, because I am saying entire turnaround 10th he was in West Bengal. This time 752 when this invoice. This he was in West Bengal. 927 he has procured. He has the tier weight was taken that at 927 in the morning on 10th. That is the specific. Well, that is he has produced, and we say from this time whatever in the evening time he was entirely in West Bengal. Now kindly come to his reply. Kindly see his reply. Kindly come to 30.
32.
Yes, the reply.
Yes.
Come to enterprise. So there were twofold allegations. That entire transaction when you were basically uploading the UA bills, it was in the goods were in West Bengal, and there was another UA bill that time also it shows to be in West Bengal. Both those allegations now how he covers. Now kindly see two A and B. You notice mentions that the weighment was not conducted at the place of origin as stated in the invoice. In this regard, the following factual submission is made. Weighment at origin was not possible due to security reasons. There was no proper security arrangement. There were frequent incidents of pilferage, burglary. Goods like aliconuts are vulnerable to theft. Therefore, carrying out weighment in that area is not safe or practical for any supplier concerned. Now, can you see? The supplier has already informed that the weighing equipment available at the origin point was not calibrated, not functioning accurately, and not certified. In order to avoid wrong declaration of future dispute, weighment was carried out at certified weighbridge whose slips is already provided. Well, if my learned contention is to be correct, that he had to he was always in the border area. He did not reach in the field as per my learned friend, because he had to go back to the Assam central point. You were saying 266 kilometers to avoid that journey. So, my lord, this contention cannot be correct, because point of origin as per the e-way bill before my lord had never came into picture, because he had never gone to that place. He has never gone into that place, because my learned friend today has told. Man, kindly see. He said he did not go to Ambari Road's Sundari Ghapa. Sundari Ghapa, because he had to go up, he had to deroute, he had to go to a different place. It was better for him to go to there. So, then what is the point of origin where they had security issues? Where they had security issues? Question is, he is saying he had security issues. Thereafter, he distract or contradict himself by saying, no, the machines were not perfect. These are the things. He doesn't say anything, he doesn't say anything on the issue of the previous e-way bill. He does not say anything about the goods were found to be in West Bengal. No, nothing, no statement of that regard. That was a specific question asked, query asked, sought from the concerned person. He chooses not to answer. He chooses not to answer. Now, my lord, what we do? Now, my lord, 39, can you see? Order starts from
39.
39, my lord. Last paragraph, my lord, would find. I'll start with Roman 3. On verification of e-way bills generated on the convention in the e-way bill portal, it is observed that prior to e-way bill produced, another event was found, but I had already placed this part. But in view of the above submission is not accepted. Now, what was not accepted? Man, kindly come to the next part. Next page. The reasons, Manu. The reasons provided by him for non-payment at the origin are not eligible, as no supporting document has been produced. The approximate distance between the purported place of dispatch of goods Dhubri Assam and place of payment is Dhubri is 143 kilometers. No sound person would supply high value of goods such as ariganas in large quantities such as without weighing the goods and the weigh the same only after traveling 143. It has also been seen from the parking slip that the tare weight of the conveyance was measured on 10th November 2025 at 9:27 am, from which it appears that the weight of unloaded conveyance was taken on 10 November 2025 at 9:27 am and weight of loaded conveyance was taken on 11 November 2025 at 4:29 am. The possibility of unloaded conveyance going to Dhubri, Assam and coming back with goods loaded and measuring the weight of the goods at PB Digital Weighbridge located at NH 31 Dhubri is also ruled out as there is no northward movement of the conveyance towards Dhubri, Assam as per the RFID toll data between so and so and so and so. Hence, the movement of goods is not genuine, and the detained good has been loaded in the conveyance and dispatched from some place in West Bengal lying between Rangoli Bajna and Hasludan, and not from the declared place of dispatch Assam or Dhubri Assam. Also, the purported consignor, Damru Enterprise, who have used the tax invoice and GST and details of Damru Enterprise so on to cover the movement of the documents are found to be false in contravention of Rule 46A of the so and so. And West Bengal puts and consequently driver has failed to carry valid documents under so and so central and so and so. Now, Manoj, kindly thereafter next page. Next page 42, the penultimate paragraph. In view of the facts discussed in previous paragraph, it is clear that the change in weighment location was not due to genuine operational and security reasons, but to evade tax. The goods were loaded in conveyance and dispatched from some place in West Bengal, lying between so and not from the declared place of business in so north, and was obviously weighed at PB Digital Weighbridge located at NH 31 Dhubkiri as it was nearest. The RFID toll data and weighment slip shows that the goods were loaded in the conveyance from some place in West Bengal, lying between Rangoli Bajna toll plaza and Kushludanga toll plaza, and not from the declared place of dispatch. It shows that the purported consignor Damru Enterprise Assam is not the actual consignor of the instant goods, and the actual consignor is some undisclosed supplier who have used the tax invoice and GST and details of Damru Enterprise Assam to cover the movement of the intercepted goods and evade tax on such. The declaration made in the documents produced is false, as actual supplier and actual place of supply has been concealed with a malafide intention to evade tax. But this is the findings. With this respect, now kindly see our single bench in a case whether appeal. Because in all the judgments, my friend has retired up. All are after appeal. Is our
Yes.
Paragraph 8 of it. Landed Council further submits that the conclusion regarding excess goods was arrived at by using a weighment slip which does not confirm to any statutory procedure under CGST Act or rules. It is contained that the respondent ought to be physically weighed the goods in the presence of the driver. The reliance on the weighman slip allegedly not authenticated or accurate is therefore misplaced. Moreover, the market rate of rupees per kg used by the respondent has no legal basis, especially when the transaction value of is duly supported by proper documentation. Learned counsel for the petitioner submit so the respondent also relied upon reasons which are not part of the show cause notice. It is also the contention of the learned senior counsel for the petitioner the maximum tax penalty imposable in the present case cannot exceed more than rupees 5,000. Learned senior counsel for the petitioner relied upon Johansson, but 10. Learned counsel for the respondent raises plenary objection regarding maintainability of the petition, asserting that the petitioner has bypassed the statutory appellate remedy under section 107 of the CGST Act. 107 uses the language any person. He further submits as per the
Facts were different.
but the question of discretion, absolute discretion article 226. Because on the face of it, on the submission also, the informations are incorrect in the given in the email. On the face of it, on the face of it. Now, I'll relax. But here, one of the question was if there is no intention to evade tax in division bench, whether simplicity there is a contravention, whether this also stands as a violation of our division bench. And I'm just one paragraph 23. Paragraph 23. As rightly pointed out by the learned counsel appearing for the state, that this statutory requirement to carry the necessary document should not be made. Paragraph 23. We are conscious of the fact that a transporter owner of the goods is bound to carry certain documents as mentioned in the Act, which are to accompany the goods. In the instant case, prior to the movement of the goods, e-way bill was generated in which tax invoice number was duly incorporated. Proof of payment of tax has already been established, and e-way bill was valid till so. And mistake committed by the appellant is not extending the e-way bill after the expiry, despite such liberty being granted under the rule. The appellate authority in the facts has accepted the contention of the appellant that the penalty amount has been computed on a higher value than the invoice value without proper evidence and reason. To that extent, the appellant succeeded before the appellate. This goes to show that he did not apply his mind to the matter and dealt with the matter. Thus, consider the totality of the circumstantial peculiar facts. Case the court is in indulgence, but 1 lakh. So, when it only contains a contravention stands. Well, a penalty can be imposed on the contravention of simplicity. Here also the after appellate also. But it's my mistake. There's another division which but this is 2025 volume 173 taxman.com 900.
दीदी একটা প্রিন্ট দিন না একটা প্রিন্ট দিতে বলে
taxman.com 900. But this is Arakan also. That's why I'm here. Paragraph 4, but I can hand over paragraph 4, but there was a direction. But for all time to come, my lord can seize this. For all time. Paragraph 4, my lord. Same perishable good, there was a direction to auction of the goods. Paragraph 4.
And you see the facts are similar. Here, the quality and the weight of the goods is not different.
Should I mark this as an exhibit? Yes.
We'll come back after 5 minutes.
No, conclude this. Then
And when my learned friend has relayed.
5 minutes back. 5 minutes.
I don't know.
Pass
Judgment has read with it, you don't know the truth. But my understanding of this judgment delivered by Justice Bhattacharya in WPA 597 of 2000.
Five nine seven.
Yes, sir. But kindly see, but here 138A was considered. Paragraph 11, madam. Paragraph 11, 138. And what was the issue before the court? Madam would find the paragraph 17. According to my understanding, radio frequency was never an issue before the single bench. It has alleged in the show cause notice that the conveyance was intercepted at a point which is not en route geographically as per declaration made in the act. The learned advocate appearing in the state in the course of argument would not point out either from the 2017 Act or the rules framed thereunder any provision which cast an obligation upon the selling to disclose the route to be taken during the transportation movement of goods. Here, my lord, we have questioned the origin. Which route a transporter is taking is not the question. Whether the origin has started from Assam itself has been questioned by us. We have specifically stated that this entire goods have been purchased by someone in West Bengal, in Jalpaiguri, in between the two places. So this was never the question before the single bench. What was the aim? Obviously, if there is a shortcut, there is a bulk, but if they can always go to a different route. That is not the question. Then the question is whether there are two vehicles in a different time gap of a half an hour. The distance is 266 kilometers. The first event and the second is about same. It's a more if not less. The question is, if today everyone goes scot-free without giving the correct information, but if this becomes a precedent, this will open up a pattern of this. Because I have kindly see the language of the statute 130 before starting of the. So the e-way bill has to be before, and I have to disclose the correct facts. These are the two precedent or the preconditions that has to be fulfilled by me. Same vehicle traveling all places, and I've shown the reply of the concerned person. Has he ever said anything on these issues?
Yes.
Well, that's why the finding of 21 comes. That's why the finding of 21, paragraph 21 of this judgment, that it was not in rule. But RFID subject to correction. If there is any other judgment, we have two judgments. In both the judgments that has been handed over, RF radio frequency was not an issue.
Here, my lord, the court has dealt with the RFID part of it.
But if my lord said
It is 1718, but kindly
1780, my learned friends, it has, I read my lord 1780. Learned advocate appearing for the state in course of order could not point out either from the 2017 Act or from the rules waived there any provision which cast an obligation upon the selling to disclose the route to be taken during the transportation movement. Well, this is never the question here.
yes, this was the
No, my lord, it is the question is origin. It will become an interstate, or it will become interesting if it is in West Bengal.
But whatever my learned
No,
friend
no.
is submitting, but if at all, they should have invoked 132. But kindly see, this is a punishment for what my
Well,
learned friend is
as
saying,
well,
but they should have invoked that.
but
They
that
did
is
not do so.
But that is.
But kindly see, Miller,
Should have
whatever
been-
allegation they are giving today, it is covered under 132. But whether they have taken a single step in respect of 132 or not. Kindly see the Miller, the punishment for certain offense. Whatever offense they are saying, they EOI bill has been falsely generated and all these invoices are fake. But these are also offense under the 132. No steps have been taken under section 132 till now.
But we'll take step.
But how, Miller, on the very inception, these were taken. Miller, these
But-
were supposed to be taken on the very inception.
Liabilities can be dual also, civil and criminal both.
Yes,
So
that
this is
true. But kindly
this
see
is
the
in
language,
respect of
Miller, I
criminal.
put your lordship. But kindly see the 2018 notification along with section
Just
129.
no statutory requirement can be worked by statutory requirement is under the rules. Before the movement of goods, it has to be generated and has to be with correct information. But kindly see, my lord has this book, 900 page. Kindly, this is the format of the e-way bill.
Page 900.
Yes,
No, I don't have that many pages. I don't have that page.
My lord, I have handled it.
Did
Place of dispatch, GST and supply, place of delivery, document number, document date, value of goods, reason. Each is a reason for vehicle number for road, transport number, so and so. This continues the next page, where the supplier description, job of work, and so on.
Everything was there in the email.
But if they have not
But
ascertained the weight, if they could not ascertain the weight and they have to come to Jalgai
No,
to ascertain the weight,
that is the gross weight.
that is the load, that is his
But
procurement.
he is-
Manner, please. Procurement slip which they have produced says they have taken the weight of the good.
Very well.
But there is no dispute regarding the weight. But they have also weighted the goods, it is same. And but they are
I'm fixing it day after tomorrow. We shall decide then. Because today I can't consume the entire day.
Wasted a lot of time.
Heard.
see not the mandate of order.
Heard it, because I have to now deal with all of this.
Yes.
So it can't be today. Tomorrow I've already fixed another one. Day after tomorrow I shall, whatever I have to do, I'll do.
But my humble prayer before your lordship is this, Lord, I am coming in terms of 129 1A. But this is for interim measure. I am not saying that your lordship.
No, 129 1A may not be interim also. If you see
Yes.
section 129,
Yes. But kindly see
see section 5,
Ah.
subsection 5.
On payment of the amount referred in subsection 1, all proceedings in respect of the notice specified under subsection 3 shall be deemed to be concluded.
So it's
Now,
final.
my case is this, my lord, but kindly consider this aspect. My case is this, my case is following 129 1A. Now, Lord, that's similar. I am saying I have not doing anything, I'm not doing anything in contravention of the act. That is the reason I have to prefer an appeal. So for the interim measure, the appellate authority decides. Your lordship can always release the goods, my lord. These are perishable in nature. My lord, can you consider that part?
Very
also?
well. So let me go through all of this.
Lordship.
Likheni. Heard Mr. Majumdar, learned senior advocate appearing for the petitioner.
And advocate record also yes 5 minutes. I'm really grateful. Yesterday I was noticed for this thing. In future it would be a problem. So I'm grateful. And only
Mr.
small
Das,
indulgence, my lord.
you keep one with you. Mr. Das, learned senior advocate appearing for the petitioner, submits on instructions, that the petitioner is that he has submits on instructions that the petitioner seeks to withdraw the writ petition as there are certain omissions and defects, with liberty to file a fresh writ petition with better particulars. Full stop. He hands up to court a copy of a letter dated December 12, 2025, written by the petitioner to the learned advocate on record for the petitioner. In such regard, full stop, the same is taken on record, full stop. Respondents are represented, full stop, as paragraph D as prayed for. WPA 11932 of 2025 is dismissed as withdrawn with liberty to file afresh. In accordance with law. Yes, yes, please give. Total letter টা রেখে নেবেন রেকর্ডে হারিয়ে না
Obligement.
Sorry for the prolonging.
না না sorry.
I also do not know how to capture the entire argument.
It's your duty, you have to do it. Yes, ma'am.
My lord, this matter was heard once, my lord, and but my lord, along with this, till yesterday, my lord, item number 28 in today's list was tagged. I mean, they were serially appearing, but today I find that this has appearing as 4.
Because this might have been mentioned for urgent hearing, and that
No,
not.
my lord, no, we did not mention for urgent hearing as to my knowledge, because I've been regularly
So it
appearing,
is
my lord.
appearing in as an এটা আর্জেন্টে appear করছে কেন দিদি? কবে
কে mention করেছিল? আমি করি। I have not also mentioned. No, 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 no. Because it was heard, my lord. It was coming in the list. It was heard.
Slip কোথায় mentioning slip তো নেই। কোথায় mentioning slip?
28 also tagged with it. My lord, if your lordship says, or I'll again have to come to 28 and later argue. The similar matters, different years, my lord.
What is the matter? If it is there, if you are ready, then we can take it.
Yes, yes, I'm ready, my lord. For 4, I'm ready. And also for 28, I'm ready, my lord. But
Very well.
my lord,
What is this?
the matter was, my lord, that I have come from the adjudication order. And I know that your lordship will ask me to, how will I surmount the hurdle of the alternative remedy? Now, my lord, there are 3 reasons. My lord knows very well when that alternative remedy is not a matter of rule but of policy, and there are 4 grounds which has been laid down in Whirlpool. My lord knows of it. To that, my lord, recently there has been a judgment of the, not recently, 2 years back, of the Supreme Court. As a question of law, if it involves a question of law, it can also be we need not go through the grinding mill of alternative remedy. Now, my lord, in this case, what happened was that the petitioner, who's a registered taxpayer, he in which year he might not purchase goods from some registered dealers whose registration was subsequently cancelled, and on the basis of certain allegations by the CGST authorities, but not by the state authorities, that they do not exist on this ground. Now, my lord, a show cause notice was issued, and into that show cause notice, my lord, the show cause notice is at page 86. That is that you have not received the goods so you cannot avail ITC under section 62B. Why? Because they were found non-existent. That is the allegation. So the entire premise of that
Page, madam, page
page, my lord, the show cause notice at page 86.
86. Yes.
71. 23. My lord, this is for the 23, 24 period.
Page 86.
Page 86. Page 86, my lord.
Yes.
Yes, my lord. My lord. My lord, there are 3 dealers. My lord, I first come to the page 86, first paragraph, claim of ITC. There are 3 dealers, my lord, and they are saying that 3 taxpayers, that the RTP such and such has claimed ITC of such and such person who is accused, means my supplier is accused of passing on bogus ITC to a number of registered taxable person. Apex Enterprise was engaged in issuing fake GST invoices in fraudulent manner without actually supply or movement of goods. ITC enjoyed by RTP, that is the petitioner, is thus not allowable as the transport and movement of goods is practically impossible from a supplier who does not have any physical existence. Now, my lord, these are there are similar 2 other dealers, and finally, my lord, page 89. 90, yes. Yes, my lord. Yes, my lord, kindly come to page 91. It says, she quotes 16.2b and says, my lord, so as 16.2 of, my lord, 91, my lord, kindly
Yes,
see
yes.
B, he has received the goods, and then, my lord, at the bottom, so as section 16.2 of the Act, one of the conditions to claim ITC is to receive the goods. The above mentioned cancelled entities had no bona fide existence and had never conducted any business activities from their places of business. It is only possible from the supplier to make outward transactions and passing on ITC only by issuing fake invoices and without any movement of goods. My lord, for this, there has been no supporting evidence provided by the respondent, except, my lord, certain, my lord, truncated portions of screenshots that, my lord, will come to kindly see page 88, my lord, which is hardly legible. That is exactly what they have stated. And my lord, what it says, if one can decipher, it says that please cancel the registration of such and such person. It does not establish that the person is not in existence. And similarly, my lord, at page 89 and page 90, a field visit report, which is also debatable because they themselves said that the authorities who went, they produced an electricity bill, and when it appears that the landlord asked, you give me the rent agreement, they said, we don't have the rent agreement. That is the authorities said. So it is not
Where
conclusive.
do I get that?
My lord, yes. My lord, kindly, it is very difficult, my lord. My lord, my lord, kindly see page 90.
Yes,
And
I'm seeing that.
my lord, it is as we have received it, my lord, from the yes. Further, the authorized officers showed them the electricity bill, and showed them the electricity bill used as proof of address subsequent while obtaining registration. In this respect, Sri so-and-so verbally confirmed that the what is written, the premises is under the name of so-and-so. However, requested to show the rent agreement issued my lord, the obtaining my lord, you will read out, I am having a difficulty in reading. Issued the obtaining.
Yes, I've read it.
Obtaining
I've read it.
registration.
I've read it,
However,
ma'am. I've read it.
yes, my lord, I have a eye problem, my lord. So now, my lord, these are some of the documents. No full documents were given, and my lord, I did file a reply. My lord, my reply is at page 95. Now,
Yes.
and at 96, my lord, I have said, my lord, paragraph 3b, I start with 3. The allegations made by you by DRC 01 dated such and such are baseless, arbitrary, and incorrect. As my lord, A is my submission, that the physical verification of the RTP as noted in your show cause notice DRC1 are not in accordance with Rule 25 of the GST Rules 2017. You have not mentioned the date of physical verification of the RTP, therefore your allegation is not sustainable. Now, my lord, come to page 97. My lord, in between 1, 2, 3, 4, 5, 6, further, 7 line. Actually, that is further. I am submitting all the supporting documents in original, my lord. Tax invoice, ledger, and bank statements, along with evidence of movement of goods. My lord, the allegation was that there were no movement of goods. Along with evidence of movement of goods in support of my claim that my transactions were genuine and that I have made all the payments through bank. Also in case. Now, my lord, kindly come to the order. Page, my lord, it is in volume 2. Yes. Yes. It starts from 318. And my lord, I am reading out the operative, how she took the decision. My lord. My lord, come to page 324. All this, my lord, narration, etc. Now, my lord, in 324, if my lord sees paragraph 3, then my lord, the show cause notice 4, then the notice on 13/325, 5, then my lord 6, Mr. Ghanasham Jha. My lord, page 324.
Yes.
Mr. Ghanasham Jha, the authorized advocate of Mr. Swanso, the authorized representative, and Mr. Swanso, the authorized representative, appeared on behalf of the notices in personal hearing on 7/4/25 and submitted his reply along with supporting documents. My lord, earlier also to the reply I have submitted now. Photocopy of e-way bill, my lord, which indicates the movement of my goods. Tax invoices, party ledger, along with bank payment statements, and opine that they do not have anything else in the submit. My lord, these are the documents which I required, that I have received the tax invoices, I have received the goods showing movement of goods, I have paid the suppliers through bank, I have my party ledger, and my lord, it is not their allegation that the suppliers have not paid the tax. The tax has been duly realized from the suppliers and they themselves have paid it. Now, my lord, all this is given. Then I'm coming to it. Now, my lord, kindly come to the operative portion of the order, my lord, page 325. Now, she says, now, I'm coming. My lord, 1, 2, 3, 4, 5, 6, 7, my lord, 7 of paragraph 2 in the 7th line.
Yes.
My lord, she has come with a preset mind. If there were no bona fide existence of the suppliers and no bona fide business activities of the suppliers, and if there were no goods involved, then how could there be any movement of the goods? So my evidence of movement of goods has not been at all considered, simply because it has gone into her mind based on those, certain documents of the CGST authorities that I did not exist. As per section 16(2)(b) of the Act, one of the conditions to claim ITC is to receive the goods. So, for the instant case, the recipient, Swan's RGM Recycling Metals, has failed to prove the receipt of the goods. It could be possible. Now, my lord, why she's doubting my e-way bill? It could be possible that the vehicle was unloaded during movement or goods were delivered at some other places. My lord, this is totally on conjecture and presumption. Entry pass documents, stock register, and other documents of like nature which proves receiving of goods have not been submitted by the RTP. Now, my lord, pausing here for a minute. Never for a moment during the adjudication proceedings, she says that I am not satisfied with your e-way bill. You produce these other documents. My lord, we have a factory. If those documents were called for, we would have produced them. What as further evidence? And my lord, now I will show why I am willing to produce other documents. Yes, my lord. My lord, kindly. Goods. Yes. Yes, yes. My lord, I am saying rule 138. Documents. Rule 138, my lord. I'm relying upon rule 138. My lord, the first condition, my lord, which is a legal condition, information to be furnished prior to commencement of movement of goods and generation of e-way bill. So far, it is a legal document. The moment I am required to carry this, my lord, she is ignoring that. And on the one hand, she is saying 325, yes. She says there is no movement of goods, and at the same time, my lord, she's also saying it could be that you have brought the goods with e-way bill, but you have disclosed it, you have delivered it at some undisclosed location. My lord, it is blowing hot and cold, contradicting, my lord. So this is, and she has totally ignored my evidences, and all the documents which she's saying that you did not produce, they were never called for. Now, my lord, after passing this, while passing this order, she is annexing some other documents like Panchnama, etc., regarding that they were not found, which were never provided at the time of, my lord, adjudication, which is at page, my lord. I'm placing it at 327. At 327 of, my lord, 329 was probably there, but it was not so legible. And my lord, what does 330 says, my lord? 330 says request for cancellation of registration. It does not say on what ground the registration was cancelled. Was the registration cancelled on the ground of non-existence? Nothing like that. Now, my lord, in this. Yeah, and this was not handed over to us, my lord, at the time of the adjudication proceedings, because it is only annexed along with the adjudication order. Now, my lord, on the earlier date, my lord, I had relied upon a Supreme Court judgment, my lord, where my lord probably has it in the file, my lord, that is
No,
Commissioner of Income Tax.
There at page 88.
My lord?
Page 330 was handed up to you at page 38. Page 88.
330, yes.
Page 88, it was there.
Yes, my lord, yes. It is a more legible copy of that, my lord. Yes, I understand, my lord, that is. And that is what I'm saying, my lord. It does not say that this is, you cancel his registration. But I had specifically stated in my reply, you please me.
No,
please.
Page 330 says that no such business entity in the name and style of Apex Enterprise is found at the declared address.
Yes, my lord. Yes, my lord, I got an illegible screenshot of this.
You could have asked for a legible one.
My lord.
That
I did. My lord, in my reply, I said, I made certain requests, my lord. In my reply, kindly, I'll again bring it to your lordship's notice. Reply to page 95. My lord, I made requests. I said that please give me. Yes, my lord. Page 96. I said that you have not mentioned the date of physical verification of the RTP, therefore your allegation is not sustainable in the eyes of law. And it is not clear as to when and where and in whose presence the physical verification has been made. I have made this, my lord. So if she wanted to, establish her own, that yes, she's relying on the
law. Was it not that it was your onus to show that they were there physically?
My lord.
Onus was yours.
My lord. Provided, my lord.
The question is posed to you, it is your onus.
My lord.
You have to discharge it.
Yes.
You cannot, by way of a reverse mechanism, put the onus on them.
No,
they have a right to raise a question. Yes. They have raised a question.
Yes,
it is for you to satisfy that no, they are there.
My lord, but we have stated that you have not mentioned.
But all these points will be available to you before the appellate authority.
My lord, now I'm stating. My lord, now what is the basis of this order? The basis of this order, yes, you have provided me with the e-way bill, but I'm not considering it. You could have. It is on the basis of conjecture, suspicion, that you could have delivered the goods in between and it has gone to somebody else. Now, my lord, for this reason,
e-way bill is generated prior to the movement being
at the very time.
So what happens in the meantime? How will the e-way bill prove that?
Then, my lord, my thing is that if it is so, then my onus is to show that this is the e-way bill.
That
If he does not,
discharge the onus.
I've discharged my onus, but
No, merely by putting in the e-way bill, that onus of showing that you have received the goods will not be discharged.
my lord,
That you are
no, she said that there is no movement of goods.
that
There was one allegation, there is no movement of goods.
the other one is of repeat
Yes,
also.
as movement of, my lord, if I have not, now, I'm putting it there. If I have not received the goods, if she had asked for the documents which she is asking for in the order, she had never asked, my lord. Then,
Documents she won't ask. She will ask you to prove it.
yes, I have said that, she said that there is no movement of goods. I said there is a movement of goods. And she's saying, no, those goods may have been unloaded elsewhere. And therefore, my e-way bill is not accepted. There is an allegation that there has been no movement of goods. Now, in this respect, my lord, absolutely my evidence of the e-way bill has been totally ignored and not considered on the basis of a conjecture that it is possible that I could have delivered it. Had she given a proof that no, under this way bill, you did not bring the goods, it was delivered to somebody else, my lord, I could have understood. Nothing like that. And my lord, so that is why, my lord, I rely on paragraph 9 of this judgment, my lord, on Commissioner of Income Tax Orissa versus Orissa Corporation. Hey, my lord, my lord, kindly come to page 114. My lord has a call. My lord,
Yes, I have.
my lord, paragraph 9 at the bottom. The court,
Celebrated Orissa, everybody.
your lordship recalls. So, my lord, all I'm trying to say is that on the basis of this, that whether the finding of the court is not vitiated by reason of having relied upon conjectures, surmises, and suspicions, not supported by any evidence. The fact that I have delivered the goods to at some undisclosed place is not supported by any evidence but based on conjecture and partly upon inadmissible material. On no account whatsoever should the tribunal have its findings on suspicions, conjecture, or surmises, nor should it act on no evidence at all or on.
Yes, I have read it.
Yes, my lord. So this becomes, it is also stated, this becomes a question of law. My lord, if I recall, on that day your lordship had said that it fell from your lordship, that this was passed by the Supreme Court after they came through all those proceedings. If that is, it fell from your lordship. Now, my lord, so what I would like to say, that this is the law of the land. So the law of the land, and it is a binding precedent, and it has to be followed by all authorities. So even the adjudicating authority should also be bound by this law. Now the next question is, my lord, whether this is arbitrary or not. My lord, this is something different. Lakshmi Devi, my lord, Lakshmi Devi, ওকে তো একটা দিতে হবে আমারটা দাও দিয়ে দিচ্ছি para 29. My lord, in Lakshmi Devi, what happened? The issue was under the Andhra Pradesh Stamp Act, my lord, they had to pay if any matter was referred to the stamp authorities for adjudication, they have to pay 50% of the stamp duty that has been adjudicated. And therefore, my lord, this was paragraph 29, 28, 29. My lord, and for this reason, my lord, that particular provision was challenged. The Supreme Court said no. It is virus, it is intra-virus, but, my lord, kindly come to paragraph 28. The Supreme Court conceived of a hypothetical situation. My lord, paragraph 28. We may, however, consider a hypothetical case. এই জাজমেন্টটা আছে দাও নাহলে তোমাকে সফট কপি দেবো নাহলে আমাকে শেয়ার করো এই সাইটেশনটা দিয়ে দাও তোমার কাছে আছে তোমার কাছে আছে my lord I'm sorry my lord supposing the current
28, 29 I have read it.
read it and 29 says my lord that in our opinion
High Court has to be satisfied that the demand is exorbitant.
Yes, and it is arbitrary if it satisfies.
That is always there, ma'am. That's
yes
always there.
So, and that is, my lord, is the violation of Article 14 of the Constitution of India. Now, my lord. Okay. My lord, now the question is whether a question of law can be adjudicated, a question of law can be urged before the writ court, and whether the writ court will admit it on this ground. Now, my lord, in this matter, as I said, it is a question of law. My evidence has not been considered. Now, latest Justice Dipankar Datta. Sir. Okay, the doctor. No. Now, my lord, the law has evolved. My lord, I'm just relying upon, my lord, paragraph 8, at page 8 of the judgment. My lord, this is from the Supreme Court site itself.
Yes, it is now reported.
My lord is aware of it, no, my lord?
Yes.
Yes, my lord is. So I'm only.
Judgment.
So if it says if it is a pure question of law and if investigation into the facts is unnecessary, the High Court could entertain a writ petition in its discretion, even though the alternative remedy was not availed of. And unless exercise of discretion is shown to be unreasonable or perverse, this court would not interfere. So, my lord, I'm relying on this judgment to say there is a law laid down. And that is, my lord, that my documents have not been considered. And also,
Which document of yours has not been considered?
my lord, my e-way bill has not been considered. My lord,
the order does not make any reference to the e-way bill.
It says she has produced the e-way bill. There is an admission that the e-way bill has been produced, but says, my lord, that the e-way bill I could have. It does not prove that I have received the goods. It could have been delivered elsewhere, which is based on surmise, suspicion, and conjecture. My lord, at 325 admits e-way bill has been given, produced, and my lord, 324 says e-way bill has been produced, and in 325 it says it could be possible that the vehicle was unloaded during movement or goods were delivered at some other place. Then she has to prove that the goods have been delivered at other place and it has not reached me. Yes. And my lord, even though I have produced for that to satisfy, she could have said, you give me, all right, I'm not satisfied.
Mr. Chakraborty.
My lord, all I'm praying, let it be remanded to the adjudicate authority to consider these points. That's all. Nothing.
First of all, this is not a case. Doctors' judgment is very clear. It is a pure question of law.
Yes.
Ms. Mukherjee submits that you have not considered the evidence that was cited. If evidence cited is not considered by the authorities, and adjudication order is passed, that becomes a perverse order, and perversity is a ground for interference.
Of one by one. Then consider what was the submission vis-a-vis 324.
324.
324.
Third paragraph. However, in his reply, the article finds that without being the DRC 01 is void. Details of which is given below. The intimation in closure has been issued to PSP on the meeting portal and has been typical signature. The annexures to form has been signed. Thereafter, the sequence, the show cause was issued with reference number while the notice was given opportunity to appear before the for personal affair to submit his reply along with support. The notice was also requested for an extension of time to furnish his reply. Therefore,
this has been placed, Mr. Chakraborty. Need not place again.
The notice is replied. Just thereafter, cited the judgment of Sankra, so and so where the case involved mismatch between versus GST 2A and the revenue department's failure to inquire with the supplier unless in exceptional circumstances where the seller is reason has closed down the business does not have any access. In the present case, the department had conducted an inquiry into the supplier found them to be not genuine. Therefore, penalizing a bona fide purchaser without inquiry does not apply. A similar case in so and so has been referred to the notice. Why the cited if the supplier is able to the payment of the tax amount to the supplier with the registered taxpayer, then ITC need not be denied. But in this particular case, the supplier never conducted it. And they use false documents to get registered on the GST app. Later on, physical verification was found. On no business activity was ever conducted. From the principal place of property, it was then the supplies were retrospectively cancelled abolition. Non-existent entity means no stock. No stocks means no delivery of goods. No delivery means non-resistant goods. Bank payments should also align with the sanitary requirement of ITC. Now next, the notice also cited the judgment of Honorable High Court at Calcutta, hearing number so and so. However, the proper officer is of the opinion that the judgment of the Calcutta High Court is so and so is not identical to the present case.
Yes, I've read that.
My lord, I'm not relying upon those judgments.
This has been relied. I'm saying there is no movement of goods because the supply was never in existence.
Where is the proof?
But question is whether this was there in the show cause notice, pre-show cause notice, show cause notice, and this was always the allegation they are non-existent. So how can you transact? So when the proof has to be on a higher pedestal. Your proof, the onus is on section 155. Kindly see when someone have to claim ITC under GST 155. Burden of proof, section 155, where any person claims that he is eligible for input tax credit under this act, the burden of proving such claim shall lie on such person. Well, he has to prove, but my allegations were in existence from the very inception. It is not something that I have developed subsequently, that you are dealing with people who are non-exempt.
Very well. Next.
Both the judgments, the question of argument. This is that I have already multi-layered there's an identification if the tribunal comes up with and thereafter there is second appeal you put down. The question is whether this interferes in a case of this nature with a factual dispute. There is a primary basis satisfaction that the law to supply the law. From inception, there is not having this. I can read from the Shukra itself, from the order also. This person's specific inquiry.
Very well. Let me touch next matter. I have heard Miss Mukherjee. I don't know. Should.
এটা পরে পাতলা না পাতলা যেটা প্রিন্ট আউট নিতে হয় দাও পুরো সেটটা
item 5 my lord. My lord, I have prepared my lord one flow chart my lord to assist your lordship my lord. Copy given.
His detailed adjudication order was not given to him, Mr. Chakraborty. He is unable to prefer appeal because of that.
One BRC 07 has to become. There are two things, but I had specific instruction that one thing that which and if there is no attachment, you cannot remember. Well, can you remind me the matter to that?
And this, my lord, I prepared to assist your lordship there.
Yes.
Because, my lord, there are
This instruction, item number 13, my lord, the last, DSC 007 should be, my lord, withdrawn. Kindly make an order and revert the back to the executive order. And, my lord, they should not insist on the limitation.
no. And, my lord, 183 circular may be taken on the cognizance, my lord, because the allegation is, my lord, mismatch of ITC TB2A. That is, my lord, much prior to show cause notice, that circular is binding. One circular, my lord, one.
What is, Mr. Rai? Please come to your writ petition. Show me your allegations.
Yes, my lord.
Don't start afresh.
সকালবেলা
First, my lord, 64, page 64, my lord, ASMNT 10.
ASMT 10.
ASMNT 10, my lord, that the allegation, my lord, operative part, my lord, at page 69. 69, my lord, 3J and 3K.
This you have replied to, right?
Yes, I have replied.
Very well. Thereafter, what happened?
Thereafter, my lord, show cause issue, intimation, I replied. Thereafter, show cause issues, I replied. In that show cause notice, that 183 circular supposed to take a.
Don't go on merits. What happened thereafter?
Thereafter, my lord, order passed. In the order, my lord, not recorded that I have submitted replies in 3 stages. And
where is the order? Take me to the order.
Yes, my lord. Order at, my lord, page. First order, my lord, at page 1, starting page 145.
145.
5 and page 149. They attach that ASMNT 10.
So your reply was not considered.
Not recorded because, my lord,
not recorded or not considered or
not
both?
Recorded and also not considered.
Both.
And only attach that ASMNT 10
instead of the detailed
detail. And section, my lord, 75 subsection 6 says that proper officer in his order shall set out the relevant facts and the basis of his decision. Read with.
Given. Very well. This is May 29, 2023.
Yes, my lord.
And next?
Next, my lord, after that order, my lord, they verbally paid to pay. We paid, my lord, at page 157.
157.
157, my lord. We paid some amount, my lord, around 1 lakh rupees, my lord. We have paid. Thereafter, my lord, they issued second order. Page 159.
159.
159. Again, my lord, they attached the ASMNT 10, my lord. It is evident from the record. Thereafter, my lord, we preferred rectification at page 169. That application not generated, portal screenshot attached. Thereafter, my lord, they passed the rectification order. And again attached that ASMNT 10.
Page?
Page, my lord, 171. Again attached. It is evident from the record, my lord. Thereafter, my lord, very interesting.
171, yes.
171. Same attachment from ASMNT.
And your rectification was rejected.
Rectification rejected, my lord. Later, prior to that, my lord, page 180, that first reply, my lord, I have in the ASMNT 10, I reply submitted ASMNT 11. In the chart, my lord, I have showed, I have marked in pencil. That dropped on 9/6/2023, page 180. If it is dropped, then everything dropped because they are accepting though drop after passing of the first order, second order. But, my lord,
which one was dropped? The original one, first one?
Yes, first one. My allegation dropped and law says, my lord.
Where is it? Where has it been written?
Yes. And that ASMNT 10, my lord, page 64.
No, dropping of that, where has
Yes,
been
page 180.
180.
Here, my lord, in the middle portion, that tax period such and such, ARN. ARN means, my lord, this is ASMNT 10, page
yes,
number.
Mr. Chakravarti.
Drop.
Proceeding itself has been dropped. No, it says reply has been found satisfactory. No further action is required.
Yes.
Page 180.
If it is dropped, I cannot improve.
No, that is your letter, page 180.
180. But it appears where there are which.
No, it clearly says in this regard, your reply has been found to be satisfactory and no action is required to be taken in the matter. See page 180. It's not a question of technical glitch. It's an order and application of mine to the matter.
And my reply was detailed.
Initially, they don't consider the reply, they don't refer to the reply. They are in love with ASMT 10, always attaching that, and then they drop entirety of it. If they have dropped, they have dropped.
Page 180. And section 61 says,
If this kind of technical glitch happens, then it's difficult. It becomes very difficult.
section 61 says, if reply is satisfactory, then no further action required.
That is in any case, even if section was not
Yes.
there, if something is accepted,
Accepted, right?
that's accepted.
Right, my lord. And thereafter recovered, my lord. Page 182.
Mr. Chakravarti, come back tomorrow then on this. Tell me. Tomorrow, only on this. Because this needs to be finished.
Yes, yes, well,
Heard Mr. Rai, learned advocate appearing for the petitioner, and Mr. Chakravarti, learned advocate appearing for the respondent. Mr. Chakravarti seeks some more time to come with appropriate instructions and get written instructions so that I
Yes, yes.
take it on record. তার আগে এক জায়গায় লিখে দিন appropriate instructions এর আগে লিখুন Mr. Chakravarti, learned advocate appearing for the respondents of the লিখেছেন তো ওখানে full stop দিয়ে দিন তারপরে লিখুন Mr. Rai, learned advocate appearing for the petitioner, invites the attention of this court to form GST তারপরে ASMT -12 dated June 9, 2023 within brackets annexure P14 at page 180 of the writ petition bracket close, and submits that by the said order, comma, the respondent GST authorities have accepted the reply furnished by the petitioner to the show cause notice issued to the petitioner. Show cause no.
No, that is ASMT 10.
To the scrutiny notice issued to the petitioner under section 61 of the WBGST Act, 2017 / CGST Act, 2017, and have indicated that within inverted comma no further action is required to be taken in the matter, inverted comma closed. It is submitted that in such view of the matter, comma, none of the demand orders that have been challenged in the writ petition, i.e. What are the dates?
My lord, first 145
matter is facing some medical emergency today in his home.
Noted. Next.
Before your lordship, my lord, this order is against the principle of natural justice, my lord. Well, I prove, my lord. Lordship comes down to page number 20, my lord. Similar of as that of Mr. Roy, accepting the reply. Accepting the reply.
Page number
20.
20. Detailed order not given.
My lord, page number 20, detailed order is 22. 22. Herein after, my lord, the SOCOS notice. That was the DSC 01, my lord, A. 27 is the SOCOS notice.
Page 27
7.
is the show cause notice.
And my lord, 29 is against the attachment. No order. Herein after, my lord, page number 34 is the final order.
Yes.
And page number 29, my lord, is the attachment.
29.
29.
Page number 34 is the summary of the order.
Summary of that. The demand notice.
And the attachment is 39.
29.
Attachment is prior to that.
My lord, I have wrongly, my lord.
Very good. 29. Detailed order not given.
No. No, my lord. SOCOS order, nothing. And my lord, lordship comes down to page number 43.
So you did not reply to that summary show cause?
Admittedly, not. Admittedly, no. I did not make any reply. Page number 43, the reason for not replying, my lord.
Page 43.
43.
Yes.
My lord, notices and orders, my lord, additional notices and orders.
And then how did you come to know about all this?
My lord, after the page number 18, my lord, 17, my lord, bank attachment, my lord.
Page 17, 18.
17, 18, my lord. DRC is 13, my lord.
Yes, Mr. Chakravarti, this has to go then again. Same thing.
Additional notices for 2024, it was corrected after January 2020.
This was after the correction. But this is still under additional notices only.
So this thing comes in under additional notice. But
So what is the correction then?
now, if someone drags or clicks it, both the
Tabs.
both the apps comes up. So someone can very well see what is there in the external notice and the notice.
Mr. Sharalia, what to do?
My lord, let it go, my lord. Let me give a reply. My lord, prima facie, my lord, there is no order. And against the order, my lord, without an order, my lord, I cannot give a reply.
Let management pay some cost 2024 order. Everyone comes to know.
My lord, may I submit, my lord? There is an order of, my lord, I wanted to bring this, my lord. No, no, sorry. দিচ্ছি রে বাবা তোকে
নিজে দেখতে পাচ্ছ না আমাকে দেখাচ্ছ
এটা তো কপি দে আমার কপি দে In fact, my lord, না এই মাংস পেশ করেছিল যেটা দিলাম কোথায়
So this division bench says to go and file appeal.
appeal or within a certain time period, my lord, let me file an appeal, my lord.
And since the amount has been recovered, some amount has
My lord, my bank is attached. Bank is attached, my lord. I'm a very, my lord, for the last 3.5 months, my lord, bank is attached.
Upon you filing the appeal and putting in the pre-deposit, it will be attachment
My
will be lifted.
my lord.
Months.
Months.
You petitioner.
compelling circumstances may cause you to mention one matter. Demolition notice was issued upon me yesterday. Date was fixed from 12 at 11 p.m. I tried I found this application and want to file the application because the department is not accepting since I mentioned the date is 11. This is which just one of the West Bengal Highway Act. The determination of just the department is not accepting unless
The demolition order is not susceptible to challenge before the appellate authority.
No, the notice was challenged. Demolition order was not passed. Demolition order, entry order was in my favor. But in spite of that, they issued the notice of demolition.
Why department will not?
I have mentioned that in the presentation from the 11th, because 48 hours, they are not accepting. Unless the court is granted leave, they are not accepting.
Leave
and leave.
But you have to serve. Without service, I will not hear. If they are not appearing, I will not hear. I'm telling you that. Ensure their appearance. I will not take expertise.
It is. Matrix law. But I traced on the last occasion paragraph 159 and 160 from the order. But if I may draw attention to my pleadings with regard to that, because of the redactions, the pleading in the petition, and then the kindly have page 41.
Page 41.
My lord. But D, my lord. Related party ethane transactions.
Page 41D.
Yes, Lord. So, firstly, the observation is reproduced. I'll trouble my lord with replacing it so that it is a recollection of what is there in that paragraph. It's entirely here, Lord. It was noted that both Equate and TKOC purchased raw material ethane for production of captive input ethylene from the related party Kuwait Petroleum Corporation. However, the same was not reported by them in Appendix 10 submitted in original response. Further, it was noted that there was significant difference in ethane purchase price reported by the two producers in Equate Group. Equate Group refused to provide copy of feedstock supply agreements with KPC to substantiate the claimed purchase price, mentioning that the said agreement contains very highly confidential and commercially extremely sensitive information, and as such cannot be submitted on record. The authority notes that Rule 7 of the AD rules, confidentiality of information cannot be claimed by the authority itself. On account of refusal of information, the authority has relied on best information available on record to compute the cost of production. It is clarified, this is the answer, it is clarified that Respondent 1 requested the above mentioned details to determine whether your petitioner purchased ethane at market prices in order to determine your petitioner's cost of production as per Annexure 1 of the AD rules. In response to Respondent number 1's email dated 14 July 2025, petitioner submitted a clarification on 17 July 2025 confirming that all details of ethane procurement from KPC were already placed on record in its earlier filing of 6 June 2025. This filing of 6 June 2025 contained
detailed information to determine whether your petitioner's purchases of ethane were undertaken at market prices, including sample invoices, the detailed pricing mechanism for such purchases, along with its working, the complete purchase register for the period of investigation. The same details were additionally presented in the format of Appendix 10. The petitioner also explained and substantiated that the average purchase price of ethane for your petitioner was consistent with the prevailing chemical market analytics benchmarks and therefore reflected an arm's length price. The non-submission of the complete feedstock agreement by a petitioner is immaterial, as your petitioner had placed sufficient information on record, which allowed respondent number 1 to determine whether your petitioner's purchases of ethane were at market arm's length prices. Indeed, there does not exist any requirement under the AD rules which necessitates that an authority must specifically procure a respondent's feedstock agreement, or that a determination of transactions at market prices can only be conducted on the basis of such an agreement. Without prejudice to the above, while the full feedstock agreement with KPC was withheld due to its highly confidential and commercially sensitive nature, your petitioner expressly offered through its submissions dated 17 July 2025 to make the full agreement available for inspection during on-site or virtual verification in the interest of complete cooperation. Such a verification had been done in the previous MEG investigation. Respondent number 1, however, did not avail itself of this opportunity and instead resorted to undisclosed best information available. The feedstock agreement is identical to the one that was reviewed by respondent number 1 in the previous investigation, that is the investigation initiated by respondent 1 on 28th of June 2021. Further, as highlighted above, your petitioner had also submitted chemical analytics benchmarks, which established the prevailing market benchmark prices for ethane. Even in a situation where the respondent 1 considered itself to be completely able to determine the arm's length nature of your petitioner's purchases, it was open for respondent 1 to use the submitted benchmark prices to compute your petitioner's cost of production. On the contrary, respondent 1 computed your petitioner's cost of production using an opaque benchmark with no details or explanation provided regarding the source of its determination or the adjustments made in the said determination. This action is not only violative of Article 16 of the AD rules, but is also evidently arbitrary. Now, I shall place the documents for E, cost allocation between product under consideration and other products, non-PUC products other than those under consideration. Observation of respondent 1. Further, Equate Group failed to provide sufficient justification for not allocating certain costs which should have been allocated to PUC. The explanation provided by Equate Group was found to be at variance with information submitted for verification. Accordingly, the authority has allocated such costs based on the information available on record for this investigation for determining the cost of production. In response to the answer, in response to respondent number 1's email dated 23rd May 2025, seeking clarification on the reason for not allocating packing material costs and research and development expenses to the PUC, the petitioner submitted this clarification on 26th May 2025, confirming that packing material and research and development had been consumed only for NPUC, that is not the product under consideration, and thus reported only to NPUC. It was also clarified that expenses reported for PUC and NPUC are recorded separately in your petitioner's accounting system and thus reported on an actual basis. Further, in response to respondent number's observation during the desk verification dated May 28, 2025, seeking clarification on the reason for allocating few expenses totally on PUC and few expenses totally to NPUC, your petitioner submitted clarification on 6 June 2025, confirming that the accounting record separately captured all expenses and incomes related to PUC and NPUC, and that no notional allocation had been made. Further, a detailed profit and loss statement was provided with the reconciliation. Despite this, the respondent 1 proceeded to reallocate certain costs to the PUC without adequate justification and contrary to the verified financial records, while relying on undisclosed information which your petitioner had no opportunity to consider or deal with. So this is how that has been criticized. And if I can just take my lord quickly to the documents on the basis of which this pleading has been made. If my lord is pleased to have page volume 3, but first of all, page 379 at 381.
81.
Yes, ma'am. No, this 6th June letter, which has been referred to in the pleadings, but D, Appendix 6 ethane complete purchase register. This was a query, my lord. APC related party arms length to be verified. So this is what they put as a query. Response. The purchase register and sample invoices of ethane for the period of investigation for ethane for each quarter of the POI are enclosed as Exhibit 4. Then this is redacted. Then the detailed pricing mechanism for ethane purchases made by Equate and TQC is explained below. Equate's purchase price for ethane, that mechanism is not reflected here, it's redacted. TKOC's purchase price for ethane, how that the pricing mechanism was described. Then page 382, it is evident from attached Exhibit 4 that the average purchase price of ethane for both Equate and TKOC is in line with the market prices published by Chemical Market Analytics report. Therefore, the purchase price of ethane for Equate Group are indeed at arm's length prices. Please note that the information herein, in line with the investigation carries, as well as verified using the same methodology by the directorate during a thorough verification process conducted on site at Equate's premises. No, this was one. Then at page 434 is there query, further query. But B and C are the further query, and not the answer, if I may take my lord's to at page 438, at 439, B and similar at 434, most of it is not redacted, and then 439 at 440. I'm sorry, page 438 at 439.
Yes.
But B is set out, and then below that response. Equate submits that it provided the details of related party transactions in Appendix 10 for raw materials and utilities, which were consumed directly in production of PUC as a part of the cost verification document submitted on 21st April 2025. Please refer to Exhibit 4 for Appendix 10, which was filled as part of the cost verification documents. Equate submits that these details were already placed on record, along with sample invoices as part of its previous verification filing submitted on 6 June 2025. Those details are now also included in the format of Appendix 10, enclosed here with Exhibit 2. The above referred filing dated 6 June 2025 is also enclosed again for ease of reference as Exhibit 3. Then what C is reproduced and below that. Response. Equate submits that the detailed pricing mechanism for ethane purchases made by Equate was already disclosed as part of the earlier submission dated 6 June 2025, and is enclosed again here as Exhibit 3. It was also confirmed that the combined average purchase price of ethane for Equate and TQC is consistent with the prevailing market prices as published in the Chemical Market Analytics report. Accordingly, the purchase price of ethane by Equate Group are at arm's length. Additionally, Equate was very concerned to hear the representative of the domestic industry disclose information on the procurement of feedstock by Equate and TQC with reference to some very specific details during the oral hearing on 4th June 2025. Such information is business sensitive and is not ever publicly referred to by Equate or TKOC, whereby the sensitivity of this information is paramount and confidentiality norms must be strictly maintained. However, Equate remains willing to provide any necessary explanation or undertake further steps to assist the authority in its examination to the extent possible and permissible without compromising the confidentiality obligations involved. Further, Equate submits that during the previous investigation on MEG, the investigation initiated on 26 June 2021 and terminated on 27 November 2024. The agreement was made physically accessible and shown to the authority during the on-site verification. An overview of the feedstock agreement on the company's letterhead, along with details of ethane procurement and comparison with the market price, was also submitted as part of the verification documents in that investigation and was accepted by the authority. In the present investigation, the same overview has been resubmitted as part of the cost verification document filed on 6 June 2025. Accordingly, Equate again respectfully requests the authority to kindly allow an opportunity during the on-site verification or through virtual verification in the present investigation to show a copy of the agreement. So not that the business people they are sensitive about the business secret leak causes jeopardy to the business. Therefore, it's not that they did not want to show it at all. They said it's already been seen. We can again show it. And what they gave the pricing mechanism, what they gave the comparison with the market prices to show that this is at arm's length. This in the that paragraph which I will trouble my lord with some more pages from volume 3, lord. Yes. But on that second paragraph, paragraph 160, page 368, the query which was made, my lord, page 368, Act 369, K, alphabet K. This is the query, my lord, regarding the allocation of the cost. It is observed that in Appendix C, packing material cost and research and development expense is not allocated on PUC, provides a justification for non-allocation along with supporting document. Then kindly see the reply, page 372, not at 375. This was K, alphabet K, the same alphabet which was in the query at page 375. That query is reproduced and then response submits that the packing material and research and development has been consumed only for NPUC purpose and thus allocated only to NPUC. Then there's a further detailed reply at page 379. But the bottom half note, A, this the petitioner's letter. A, what is NPUC? Nature and details. Some of the expenses are allocated only to NPUC and some of them totally to PUC. Equate submits that it is also provided in so which has been considered as NPUC in Appendix 7. It further submitted that the expenses and incomes of both PUC and NPUC are recorded separately in the accounting system, and a detailed profit and loss statement for each has been provided. Further, a detailed reconciliation of Appendix 7 with the profit and loss statement along with supporting documents from staff is enclosed as Exhibit 1. A summary of the reconciliation is also provided below for reference. Then the figures are given, then accordingly it is submitted that all expenses and incomes recorded in Appendix 7 for both PUC and NPUC are directly linked to the separately maintained profit and loss statements for each. So this was the response note to. If I may take my note back to the order itself, page volume 1, page 123, 124. Page 124. What 124, paragraph 159 and 160. Yes. Not 159, the first part is saying that I had not given the agreement. And then after the italics, the authority notes that under Rule 7 of the AD rules, confidentiality of information cannot be claimed by the authority itself. On account of refusal of information, the authority has relied on best information available on record to compute the cost of production. So not the other things which I had given, not the other submissions which I had made, the market price comparison which I had given, but none of that is adverted to just referring to this agreement, and that too, my lord, it is not an outright refusal. My lord, there was a request to do an on-site as it was done in the past, or see it online. It is not my lord, that I outrightly refused. I did not want to give a copy, but I wanted to show it. But it is not that. But the other things do not find mention. The only ground, my lord, is that I have refused. And then they say best information available. Not this best information available. We cannot cannot be found from the order what this information. The absolute figures there. My 100 has now become 140, 141. But not how, I do not know what. I kept asking for it. It's never. I do not know. My own figure has been altered, but I do not know what has been done to it. And then paragraph 160. Further, Equate Group failed to provide sufficient justification for not allocating certain costs which should have been allocated to PUC. The explanation provided by Equate Group was found to be at variance with the information submitted for verification. Accordingly, the authority has allocated such costs based on information available on record for this investigation for determining the cost of production. But the first two sentences are not English. But I cannot see the material backing. Absolute statements not without anything to back it. Not. And then again, not based on information available on record. Not that information again, not the order does not reveal what that information, nor was it is given to me. Yes. I mean, as far as the law is concerned, look, on this, I will refer to the judgment of the Honorable Supreme Court in Reliance Industries case, and then the judgment of the paragraphs 37 to 42 at page 9. Yes. May I please? We are of the opinion that the nature of the proceedings before the DA are quasi-judicial, and it is well settled that a quasi-judicial decision or even an administrative decision which has civil consequences must be in accordance with the principles of natural justice, and hence reasons have to be disclosed by the authority in that decision. Why so and so? We do not agree with the tribunal that the notification of the central government under Section 9A is a legislative act. In our opinion, it is clearly quasi-judicial. The proceedings before the DA is to determine the list between the domestic industry on the one hand and the importer of the foreign goods from the foreign supplier on the other. The determination of the recommendation of the DA and the government notification on its basis is subject to an appeal before the CSTAT. This also makes it clear that the proceedings before the DA are quasi-judicial. In the present case, the non-injurious price computed by the DA was much lower than that computed by the appellant. And the reasons for such variance and detailed calculations were not disclosed by the DA to the appellant. No good reasons were given for reducing the cost price of electricity supplied by the appellant produced in its captive power plant. This was clearly illegal. The DA claimed confidentiality from the appellant about its findings on the data supplied by the appellant itself. In our opinion, there was nothing confidential in the matter, and hence reasons for not accepting the appellant's version should have been stated in the order of the DA. Then that Rule 7 regarding confidential information is set out. Then 42. In our opinion, Rule 7 does not contemplate any right in the DA to claim confidentiality. Rule 7 specifically provides that the right of confidentiality is restricted to the party who has supplied the information, and that party has also to satisfy the DA that the matter is really confidential. Nowhere in the rule has it been provided that the DA has the right to claim confidentiality, particularly regarding information which pertains to the party which has supplied the same.
In the present case, the DA failed to provide the detailed costing information to the appellant, on the basis of which it computed the non-injurious price, even though the appellant was the sole producer of the product under consideration in the country. In our opinion, this was clearly illegal and not contemplated by Rule 7. Amrad, in our case, they have not claimed confidentiality. They say it's been disclosed. But what that disclosure is not there. That is why they are before my lordship. Now, this is one, and then and this judgment was cited in a representation to the designated authority. It was extracted. The other judgment which was also relied upon in the representation is of the Honorable Gujarat High Court in the case of Nirma. It is. I refer to two paragraphs, paragraph 129 at page 53 and paragraph 144 at page 63. But paragraph 129 first, at page 53. But SCC Online does not have the head notes, so therefore, one is on, one has to find the relevant word. But not this. My lord will find that discussion at page 1.
The notes at times are very misleading.
Yes, no.
Very misleading.
Not.
Somebody puts his own thoughts and then
yes,
very dangerous to rely on it.
But then at page 53, my lord will have paragraph 129. As can be seen from the findings recorded by the designated authority on various parameters relevant for the purpose of coming to the conclusion as to whether or not definitive measures are required to be applied, it has placed reliance on certain information for the purpose of arriving at findings which are essential facts. All the information which are relied upon by the designated authority, to the extent the same is not protected by Rule 7 of the rules, was in the nature of necessary information which should have been disclosed to the interested parties to enable them to comment on the completeness and correctness of the facts that were being considered by the designated authority, and to provide additional information or correct the perceived errors and comment on or make arguments as to the proper interpretation of those facts. The entire body of facts essential to the determination that must be made by the designated authority before it can decide whether to apply the definitive measures are required to be disclosed to the interested parties. A perusal of the tabular form regarding the data which are reproduced in the disclosure statement reveals that at various places, instead of relevant data, the table contains asterisks, which would indicate that such information is confidential. While it is true that such information being confidential in nature cannot be disclosed in the disclosure statement itself, it appears to be the general practice to provide the same to the parties separately. However, in the facts of the present case, despite the fact that the information has been furnished by the domestic industry itself, the computation of the various factors referred to herein above has not been furnished to the domestic industry. In the opinion of this court, it was incumbent upon the designated authority to furnish the relevant facts which have been used by it as the basis for arriving at its conclusion on the essential facts necessary for the purpose of arriving at a decision as to whether or not the definitive measures are required to be applied. Non-disclosure of the essential facts is therefore clearly in breach of the principles of natural justice. If I may just emphasize on certain words used in the second last paragraph. In the opinion of this court, it was incumbent upon the designated authority to furnish the relevant facts which have been used by it as the basis for arriving at its conclusion or then on the essential facts. The underlying facts, on the basis of which the essential facts have been mentioned. That is what I have been asking. They have said, they have given me that 100 has become 140, but not on how. That is completed. Then just one short paragraph at page 63, paragraph 144. With the Having regard to the principles enunciated in the above decision, it was incumbent upon the designated authority to furnish the computation of non-injurious price and other factors which was based upon the information provided by the petitioner and could not have claimed any confidentiality in respect to such information. Non-furnishing of the computation of non-injurious price is therefore clearly violative of the principles of natural justice, as the petitioners were deprived of an opportunity to deal with the same while filing a response to the disclosure statement. But that's the summary. Then the last authority note is of the Honorable Supreme Court note in Hakeshwari Cotton Mills. Note, I shall refer to page 779 and then 782, 783. But 779 gives a very bird's eye view of the facts. And you see the last paragraph of page 779. The sum and substance of these decisions is that the income tax officer estimated the gross profit on sales at 40% by a pure guess, while the tribunal reduced it to 35% by applying some other rule of thumb. It is not clear from either of these judgments on what materials these estimates were based. Then we kindly have at page 782. The second new paragraph, bottom half of the page. As regards the second contention, we are in entire agreement with the learned Solicitor General when he says that the income tax officer is not fettered by technical rules of evidence and pleadings, and that he is entitled to act on material which may not be accepted as evidence in a court of law, but there the agreement ends. Because it is equally clear that in making the assessment under subsection 3 of section 23 of the Act, the income tax officer is not entitled to make a pure guess and make an assessment without reference to any evidence or any material at all. There must be something more than bare suspicion to support the assessment under section 23(3). The rule of law on this subject has, in our opinion, been fairly and rightly stated by the Lahore High Court in the case of so-and-so. In this case, we are of the opinion that the tribunal violated certain fundamental rules of justice in reaching its conclusions. Firstly, it did not disclose to the assessee what information had been supplied to it by the departmental representative. Next, it did not give any opportunity to the company to rebut the material furnished to it by him. And lastly, it declined to take all the material that the assessee wanted to produce in support of its case. The result is that the assessee had not had a fair hearing. The estimate of the gross rate profit on sales, both by the income tax officers and the tribunal, seems to be based on surmises, suspicions, and conjectures. It is somewhat surprising that the tribunal took from the representative of the department a statement of gross profit rates of other cotton mills without showing that statement to the assessee and without giving him an opportunity to show that the statement had no relevancy whatsoever to the case of the mill in question. It is not known whether the mills which had disclosed these rates were situated in Bengal or elsewhere, and whether these mills were similarly situated and circumstanced. Not only did the tribunal not show the information given by the representative of the department to the appellant, but it refused even to look at the trunk load of books and papers which Mr. Banerjee produced before the accountant member in his chamber. No harm would have been done if after notice to the department the trunk had been opened and some time devoted to see what it contained. The assessment in this case and in the connected appeal, we are told, was above the figure of rupees 55 lakh, and it was meet and proper that when dealing with a matter of this magnitude, not to employ unnecessary haste and show impatience, particularly when it was known to the department that the books of the assessee were in the custody of so-and-so. We think that both the income tax officer and the tribunal, in estimating the gross profit on sales, did not act on any material but acted on pure guess and suspicion. It is thus a fit case for the exercise of power under Article 136. In the result, we allow this appeal, set aside the order of the tribunal, and remand the case to it with directions that in arriving at its estimate of gross profits and sales, it should give full opportunity to the assessee to place any relevant material on the point that it has before the tribunal, whether it is found in the books of account or elsewhere. It should also disclose to the assessee the material on which the tribunal is going to found its estimate, and then afford him full opportunity to meet the substance of any private inquiries made by the income tax officer, if it is intended to make the estimate on the foot of these inquiries. It will also be open to the department to place any evidence or material on the record to support the estimate made by the income tax officer or by the tribunal in its judgment. Then tribunal, if it thinks it, may remand. So this is not the principle of best judgment assessment. Normally, Rule 16, the disclosure of essential facts entails not just the facts, but also the underlying basis for those statements. Because an absolute statement without the material is not sufficient disclosure. Now, the requirement of Rule 17 to the final findings. That the final findings, if affirmative, shall contain all information on the matter of facts and law and reasons which have led to the conclusion, and then shall also contain information regarding. So, all information on the matter of facts. It is not discernible from the order, because it's, as I submitted, it's a conclusion, a blank conclusion, without disclosing. My prayer, in the petition is that, insofar as I am concerned, this determination of 102 is completely in violation of the natural justice, completely flawed, because my submission had been very different, that there should be no anti-dumping, there's no dumping margin at all, because this is the difference between the normal value and the export price. So for determining the normal value, they need the cost of production. So when the cost of production is tinkered, 100 became 140, the normal value went up by 69%. Therefore, the dumping margin was 178% as opposed to my negative figure. So I have actually, the challenge in my petition is only with regard to the determination made in my case. I am not concerned with the others, because if this duty will come, my case is that I'm somebody who should not be subjected to this duty, because there's no justification for this figure which they have written. Those answers.
Yes, Mr. Nash.
I think the state should go ahead first. Or the customs department.
It's union.
But I have not yet been able to come out of my habit of using the statement. Sorry.
Won't be taking more time, kindly comes to the supplementary affidavit which they have relied regarding the cause of action,
Supplements, yes.
But I am pressing page 2, of the supplementary affidavit. I said that your petitioner has filed a petition being number such and such before the Honorable High Court in Calcutta under Article 220 of the Constitution of India 1950. Your petitioner in the aforementioned writ petition has challenged the final finding notification, which is also under challenge here, issued by the respondent number 1, recommending the imposition of anti-dumping duty on imports of MEG originated or exported from the state of Kuwait, the Kingdom of Saudi Arabia, the Republic of Singapore. In absence of any alternative and efficacious remedy, your petitioner has filed the present writ petition on the grounds of the impugned final finding, which issued in gross violation of the principle of natural justice and suffer from non-application of mine, procedural impropriety, and manifest arbitrariness. I say that inadvertently details of the next paragraph, details of export of MEG by your petitioner to wholly export were excluded from the writ petition. A purchase order from MEG was issued by IVL Dhanushari Petrochem Industry Private Limited to your petitioner on October 13, 2025, my lord. This is important, my lord, the date. Which your petitioner generated a commercial invoice on November 3, 2025. Your petitioner dispatched consignment of MEG on November 3, 2025, my lord. My lord, the investigation, my lord, kindly comes to my lord, page 64 of the writ petition, my lord.
64.
My lord, page 64.
Page 64.
Point number, my lord, L. Page 64.
Page 64. L.
L, man.
Yes.
The period of investigation for the purpose of present investigation.
It is beyond that period.
Right.
Yes, Mr. Bhatt. Next.
My lord, regarding the natural justice, my lord, whether any hearing was conducted, my lord, whether every opportunity was given to the petitioner, my lord, that has everything has been explained, my lord, in
No,
final order.
The contention of the petitioner is that essential facts have not been supplied, essential facts in the nature that the process by which you have increased it from 140 to 100 to 140, the percentage. How did you arrive at that figure? What was the basis? That is what has been said, that since this basis has not been supplied, I am in the dark. This is what the contention is.
So that I understand, my lord, well, for that, my lord, I have, at present, my lord, I have no answer, my lord, because what Mr. my learned senior counsel, my lord, has entered into the facts of the case, my lord. For that, my lord, I am only on the grounds of, my lord, the preliminary objection in respect to, my lord, the territorial jurisdiction, as well as, my lord, for the cause of action which actually arose, my lord, the period of investigation, my lord, that is important, my lord. Well, that is not within the period in which the supplementary affidavit has been filed, my lord. My lord, that is also important, my lord, regarding my lord, junior, my lord, has already indicated, my lord. That is, my lord, so far the Article 19 is concerned, my lord. Article 19, my lord, the foreign entity cannot enjoy, my lord. Article 19, my lord. That is only in respect to Article 21, my lord. That is also, my lord, in respect to my preliminary objection, my lord. And with the other portion, my lord, has already gone through, my lord. I have already supplied, my lord, the judgment, my lord. Other than judgment, my lord.
Yes.
Separate judgment, my lord. That is, my lord, ONGC, my lord. Probably, my lord, is everyone is aware of that, my lord, that judgment, my lord. ONGC versus Utpal Kumar Basu, my lord. So that is, my lord, that is the.
You want to cite,
my lord, territorial jurisdiction, my lord, the cause of action, the bundle of facts, everything as well, my lord. My lord, the petitioner, my lord, deliberately, my lord, has attracted the jurisdiction of this Honorable High Court, well, instead of where the respondent, neither the respondent office nor the petitioner office is within the jurisdiction of this Honorable High Court, my lord.
You want to cite that formally? You
My
can
lord.
cite.
The only thing, my lord, that is not, my lord.
Not a problem. Very well. Whatever you have, you can give.
Three judges with judgment, my lord. Page 716, my lord. Mainly, my lord, paragraph, my lord, 5, 6, 7, 8 and 9, my lord. Part of cause of action, in order to attract the cause of action, my lord, only one thing, my lord, because since there was a transaction, my lord, in Huldia Port, my lord, that could not be, my lord, a ground for attracting, my lord, the cause of action, either partly, my lord, cause of action that the petitioner cannot, under Article 226, my lord, to attract the jurisdiction of this Honorable High Court, my lord.
Yes.
My lord, senior friend also, my lord, failed to, my lord, the damage which they have suffered, my lord. That is, that also they have visibly failed to, my lord. But I'm not going into all these facts, my lord. If my lord is satisfied with the objection which has been given by preliminary objection, my lord, that has been.
No, you raised the point of violation of natural justice also.
That,
and not applying essential facts.
That is purely on the basis of the facts, my lord. Purely on the basis of the question of law and facts, my lord. Not in respect to the law, my lord, also.
Yes.
But I am also relying, my lord, on judgment of Bombay High Court, my lord. No, that is also. 2021 PMI 1305. 2021 1 PMI 1305, my lord. But I am relying on page para 27, 28 and 29, my lord. In respect of the, my lord, violation of natural justice, my lord. So that is also, my lord, mixed question of facts and law, my lord. Paragraph 27, 28 and 29, my lord. Oh, sorry, my lord, I also could not prepare myself because of a high fever, my lord. And my lord, one more thing, my lord, your lordship kindly comes to, my lord, page 434, the redacted portion, my lord. But even in the, my lord, writ petition, my lord, which are also not confidential, my lord, they have also redacted the portion, my lord. Even the failed message that has all that those failed messages have also not been annexed with the writ petition, my lord. The failed messages are also with me, my lord. If your lordship kindly go to the failed messages and, my lord, 434, my lord, the redacted portion, the redacted. The mail which was sent by the authority to the petitioner, my lord.
434.
Page 434, my lord.
Yes. Yes.
Well, we also did not, my lord, give all the reply with respect to the EQR, my lord. Well, that is my humble submission, my lord. They have also redacted the portion, my lord, in order to achieve some unlawful gain, my lord, by redacting the portion, my lord, in the restitution, my lord.
No, the reply that was furnished to the authority, that was not redacted.
My lord, that is also redacted, my lord. It was page 434, my lord.
434 is one which has been filed, so that you cannot have, I mean, the other side cannot have.
438, my lord, also. 434, 438, my lord. Even the question, my lord, that has also been redacted, my lord. It's page 438, my lord.
Yes, but with the designated authority, it could not have been redacted. It could have been, with the designated authority, it was filed in completion.
No, that was one. But my lord, that has not been, my lord, while filing the restitution, my lord, they have redacted all this portion, my lord.
So that the other respondent cannot have.
Well, that is, well, that is the humble submission, well, my lord, the equal, that is also, my lord, not so confidential, my lord. Question have been redacted, my lord. How can we, my lord? The other day, my lord, they have supplied the copies of the portion which has not been redacted, my lord. But the writ petition, my lord, they have redacted the portion prior to adding of respondent number 3 and 4, my lord. While the writ petition was filed, my lord, respondent number 1 and 2 was there, my lord. Were there, my lord. Respondent number 3 and 4. It was not in the mind of the petitioner, my lord. Respondent number 3 and 4, they will be inserted as party respondent following the direction of this Honorable High Court, my lord.
Very well.
That is helpful.
It's Mr. Ransom. Please.
Day after tomorrow, if it's possible.
Day after tomorrow, we can have it at the same time.
3 o'clock is my lord at the other division.
Yes, division bench every Thursday will be having.
You know, starting today when I'm making Christian salary, so
Very well. And Mr. Raju, what about the other writ petition? We have been passing orders that I've never heard. We are adapting his submission. What about the same pages, same argument? Give me that page at least. Page, give me the page. Second writ petition का दिन ना दीदी. Forest tax दिन. Page 20. Page 20 of your writ petition, yes. And your replies are also on the same lines as that of the first petitioner. No, you show me where are your replies and how has the designated authority dealt with your replies. So that's important. You show me the order and Page 127. Page 127. Paragraph. One one two. Yes.
Kuwait olefin. Well, they have determined the injury margin identical to the equate group.
Yes.
Yes, Milad. Now, Milad, kindly come to page 127.
127 has been placed.
It has been placed. Milad will see that there is no specific finding against TKOC. If you see, Milad, it's only equate group. Equate is there. And Milad?
Yes.
Milad, sir, one fact I'll point out that the local councils for both equate group and TKOC are the same persons, Milad. Both have given almost identical replies. I have, Milad, just pointed out the variation, the mild variations are there on record for these two petitioners. Otherwise, Milad, the grievance is identical. Milad, will kindly come to with regard to Milad, there are few variables which has been discussed in the final finding, which has led to the upward rise. And Milad, my explanation on those, one of them was that the raw material used. How do I determine the raw material? Milad, will kindly come to page 362 of my petition.
Yes.
Milad, we'll see, Milad, the cost has been given in the bottom part of the
362.
Yes, Milad, 362.
Yes.
Milad, with regard to raw materials, Milad, I have provided an information. PCOC submits that a detailed explanation regarding the sourcing pattern, various raw materials and utilities, along with additional information supporting arm's length price for various internal transfers between parties was provided. Milad? Milad, thereafter he explains, Milad, that the cost aligns with both the product under consideration and not under consideration. Milad, this I wanted to point out to show that, Milad, I also adopt an arm's length price, and Milad, the arm's length price that I determine is applicable for the other group also. So this point I wanted to mention. Milad, again, I have one point was raised that I have not given appendix 10. Milad, the details I have given appendix 10, and Milad, as part of my reply, I have also furnished that information and reiterated it. Milad, will kindly come to page 430. Yes, sir.
Yes.
Now, my lord, will see paragraph B, middle of the page.
Got it.
Yes, my lord. I have relied upon a trade notice, and I have said that the trade notice that you publish, I have followed the mechanism provided by it. I have filed Appendix 10 and Appendix 6. So, my lord, and most of my other replies are almost identical.
Next case.
Yes.
Yes.
In this matter, I don't know sufficiently accumulation.
No. There is no recording, there is no filing. দিদি আলাদা করে রাখুন, কেটে রাখবেন, কেটে রাখছেন না, এমনি দিয়ে দিচ্ছেন, অসুবিধা হচ্ছে। আজই বলেছি আর টিকিটটা নেবেন আলাদা আলাদা। এটা প্রথমেরটা লিখে নিন। হার্ড মিস্টার make submission from that. Mr. Basul under advocate. Implemented for the Yes. But I have filed an application which I had mentioned on the last occasion, Lordship, for intervention in this matter. But I will only take 2 minutes to indicate why I filed this application and how I have no intention of stalling the proceeding. But if Lordship kindly pleases, I'll place in 2 minutes. I'll place him. Let him press his petition. Let me see. Very well. But I would have taken just 1 minute. He's in the midst of reply. Let him conclude so that it's great. Very good. No, he'll not take 1.5 hours. Yes, yes, don't take 1.5 hours because in reply, if you take 1.5 hours, then it will be difficult. Number 1. Yes. That is not part of the writ petition. Writ petition is but Mr. Mehta, the scope of the writ petition is show cause. Beyond that, that's not the scope of tenancy. Yes, take it, Mr. Mehta. Nothing turns on this.
What applies to directive applies to letters. Then another point that this was very important.
His arguments in sum and substance was that he has power to issue notice. He has power to issue directions. He has issued it. He has issued and that is not such a notification which requires to be published to attain validity. It is not required to be published in the official gazette for it to become valid because it's not in the nature of a government notification. It's a notification by an authority asking all of them who are controlled by the authority to abide by it. He has published that. So even if it is communicated by way of it being brought on the portal, that is communication enough. A formal publication in official gazette is not required, and non-publication thereof in the official gazette will not put a stamp of invalidity on the face of the notification. Yes, that is his argument. Please forget that. We are not going into that. You answered this point, whether they have power or not. And now what they are that all directions of the some breach of and it will be important that this is a function for which there is another currency provision will be affected when it is communicated by my second point. I don't have a big they are not connected. Very person. In the academic statement, some examples of mail dispatch. Is that mail dispatch? What was the campaign that was given? That this letter was communicated. And that this is not yes.
Attached notification 22nd December 21 timing is not there. That is also not there. That this is the notification. So this fact I brought it to the notification what while I was arguing. And this was not and after that when I got a print from the notification, which were all there in the time. And what I found was
yes.
That this was not in the list of acts and notifications in their order. And I annexed that at page 98 of this, and at the time of making submission, that this was not in the list of notifications in the act portion of this. Finally, after this look at page 98, this fact is also not being remembered. Page 98.
Page 98 of?
This I downloaded from their site, whatever was there.
Page 98. Yes. Hmm.
Number of this pancake this notification it is not there. 101 is not there.
101 it is not there, 102 it is not there. Then you have to finally come here, 108. Notices and circulars. In this notices and circulars, certain normal procedural things of their discussion, FSSI and authority, etc. are discussed. In that, they include one without any substance, without giving any date, etc. When I took print out one by one, I found out these two ones and I took the print. And when I took the print, I printed it in my reply. That is at page 148 and 149. I submitted that this was expressly planned because there was no number occupied on a website. So page 148 is what I got it from there. And
148.
it's taken from there. I downloaded and it closed at page 148 and 149.
Yes.
The top melody is 201 is being mentioned. This is a postal number of a dispatch that is sent by. It can't be something which is being on the website. Because in a website, document is not considered. So it is a document which is sent to somebody and they are otherwise, it's a normal first which I have put in a normal case, what happens? At page 150, another there is no such number of posters. I have downloaded from there. So what I submitted was that this was something which was planted after I started submission. And second thing was also this when the argument was this argument that this notification was never notified, in fact, has been stated and recorded in the order of 29 July 2025.
He says it is not required to be notified.
That have not been notified. If they are directly speaking the meaning of has been notified. Notified means in no manner notified. This in the letter notified through email. Now, this fact is not being clarified after the order was in 29 July. The losses pointed out this fact in the reference that this is your cat. What is your now? It's different. He made it cut that notified means notified in the gazette, not notified to the this is really not this explanation is not there in the affidavit. Now, why is the explanation not there? Why the dates are not there? When it was being put in the notice board, etc. And then why it was being sent only to producer explanation for this right now? Because this is a notification. This is to be regulated. This is to be implemented by law enforcement. You are the implementing entity by asking myself. Custom authorities will implement or law relating to any violation of any provision of any act will become violation of that contract. And if it is not being followed, suppose if I am carrying currency more than $1,000 without this, it will become an offense because it is violation of other act. of the custom that is a good which is hours of confiscation. If it is contrary to the custom tax or any other law for the time being enforced, any other act law for it. So law enforcement is not being informed. Person who will be judging this matter of assessment. If custom authority take an assessment, they do the assessment, custom authority do the assessment. So a law which is to be implemented has to be told to the implementing agency that
I've taken that point.
There is no clarification on this. That is I'm just saying 100 this any other apps also is included.
Yes.
These are imported or imported are brought within the instance of the model or the purpose of the instance. Contrary to the prohibition imported by energy that or any other of for the time. So, if this thing export is being done contrary to the TF is a part of customs manual, which is being administered by the customer. So there is, and if it is being administered by the custom authority, then there will be a circular and notification by the board also and under the act also. So that is proper. So it's only positive right now for the moment. But if the custom authority is granted an exemption, similar exemption unless granted by the TFT won't operate because we are too big. They will be for the and custom authority is for other notification for the operation of that unless both notifications come, it won't do. I again put it like this. The exemptions are issued by the Ministry of Commerce that is important. Now, they will not, these will not be free because the Ministry of Commerce under the Policy Development Regulation Act has notified unless custom act issues the reciprocal exemption notification under Section 25. So all these prohibitions which are issued were written on together. One contract foreign trade already Section 25 of the customer. So there is no 25 to all operate with Section 25. This power to grant exemption tax side. But then the law operates, then the legal operates. Legal doesn't operate like when they are not operating it. Power to grant exemption from duty. Federal government is to do it is that they can put as a person tax. This is general thing. Now, when if it is the law, under the TR, a declaration which is required under the TR, unless I have a permission to export from there, I can't put that if I try to put my it is there, it is under the TR, it is under the custom code. So if it is a point of law, then custom authorities have to have, and foreign trade development authorities also need to have, and FEMA authorities also have a similar operation, and this has to be done for the purpose. They are also custom authorities are making assessment allowing us to export them. But these assessment orders are assessment orders available any part can object. When I have filed an application before the license board, they have allowed me permission to export after seeing the license.
Yes. Cut it down. It's a matter.
I'm not saying anything. I'm not saying anything. What I have said earlier also this is one it is being all the certificates are being and those are can be recorded. When they are not in restricted or challenged in the main process. Now they are sought to be distributed in the collector. The point will be this without any application of then thereafter the customer group had made the assessment that is plain and clear on the notice board, on the website of water treatment also. Then they are and thereafter then the by the normal agency, which will be taken them on the it is not by the minor, that's the agency that was not in its and it submitted to and one of the and this was the wrong something submitted principle for and again that it is there.
Yes, which page? Page 17.
Majority number of commercial industry seem to happen on Kali Road. Now, there is another document. This is it was in last 4-6 months. In last 4 years, 3 years, 4 years, I have been made export hundreds of thousands of by different agencies who are able to take on their ones and say that the country was not it was complete, it was in the list. They are pending one document to the department very likely under which that they have to inform this the department. They are very informed that this document they have no access. Their own agency has done it, which is their agency. Their agency has done something which they have. Now, for me, okay, we want to see what to be done, whether I got them personally. They have followed the law and it was to be done. It was to be done by them at the time when applicants were done a certificate for issues.
Very good.
My point was another document was being given by this that export inspection council.
Yes.
About the page 1. Procedure of interested parties who are direct getting non-preferential certificates for etc. website on the export council needs to get the following document non-preferential then on the next or the key of the application from switching all the standards to examine the document submitted to the application to ensure the I have made the application. Well, every task there is no suppression. There is no case of suppression. What is there is you have the huge point first. Is there point at the multi-ocean which according which under the substantive law of the country do not exist. And whether when I say this that I have used the speak in this percentage and this full detail, whether this does not mean that what I want to say or they will only understand unless it is multi-ocean or then they want to be otherwise they want to be then entire and that box is filled up by them. That box is not filled up. I give them what they can say. There is no now 96 is 3.1. There are only two things which I have to suppose you know now what's the substantive law and the can ask you. Any exporter of the one know that any exporter of eligible to obtain certificate of origin from concerned candidate to export registry Thus, the holding requirement at the beginning of the production. The holding not holding. Then this criteria are holding produce and not holding produce. If there is nothing like this, that has category would be helpful. This down the substance. Then increasing the income is what is now I said that what to now they are quality is the entry in the box 8. That this entry in the box number 8 can be explained by the certificate of the perfect. I am not doing. They are reading. They are certification officer of EIA. Confirming the criteria mentioned below. A, B. Is there anything multi-origin? I tell you what the first concept has been plotted. This is a concept which is being plotted by what's the Polish power, so that India's export is totally shattered outside India. So it can be done. It can't be done because multi-origin nobody understands.
Yes.
After being satisfied that application in the conformity with the rules of origin as per hierarchy certifying officer of the time, they use a in the structure and banking access.
Got it. It doesn't say multi-origin. That is what it is.
Then what document to be
Got it.
now this certificate the 1 year their operation own keyboard and that. But this certificate what is also operate between two other countries. India, Indonesia, Sri Lanka, etc. Everybody will fight to the end for saying that fight. Nobody can campaign this because it is ultimately now the certificate is given by Indian authority. Why is it sent to by the Indian side, to the designate officer, by just to the designate officer of the other country that this is the certificate we have issued and we give that proper concession and to give the goods of the other country. Every day it is American percentage, I will see that 40%, etc. So these are things we usually we operate. But I suppose if there is example, this certificate, Malaysian country could object with I for 120.
Next point, Mr. Mehta.
So there is nothing like that. My point number 4 is there other notifications are being complied with by and that is actually not. There's that other notification. I might have go to the and we do know what to do. The same. In detail, they are compliant.
Yes.
Relevant other are not getting no directions. In paragraph, no carry out business or no exportable exports, imported except as an IT. There are no jobs. There are only maximum of our and the 34 but reiterate. that all importers, thereafter importing for export, exporters have mandatory offer to notification from importer, who are importing and exporting. That is already there. Otherwise, there is no place to go. Yeah, I have a staff vendor at A place, I have to go and apply it this place. Now they say I'm complying with this and not complying with something reality. So I will fix one notification there, you have to maintain a good control. Now you say that you are complying with this, and you are not complying. Whether it is something that
So it is not something new, it was already there, so you are complying with it. That is your submission.
that it is particular to this. I think I believe from the time that my declaration particular is notification.
So even without this notification, clearances were required to be obtained, you are obtaining that. That is your submission. Yes.
That why there was a crackdown from this, which there were no other state notification. And thereafter, they say it is not a notification. After I say that there are rules of business under Article 27, and under that, there are procedures. This notification is like whatever. Three government authorities are departments by department. Customs Revenue, Ministry of Finance, Ministry of Finance. Three ministries are concerned with this, and the notification which will be affecting all three can be issued one by the deputy, the chairman of the court. A notification is required to be vetted by the government under the rules and by the secretary. And this head which is missing, but the notification can see the notification again. The head which is missing, who is the possibility should have gone past the secretary, Ministry of Finance, and they were not supposed to say. Page 42, the petition. Section 30 is not there. 33 is 30 section 6, rather they are saying this notification to the ministry. The Ministry of Commerce, they have to budget this that. Then it will go to the law secretary, thereafter it will go to interdepartmental secretaries, etc. Who will pass? I will have to your this I have rules I have annexed in my report.
Yes, it's a placed it also, placed it.
I have to take it for such etc. I will profit so this is a climb down after that. This is not a notification, otherwise throughout they are doing notification. But the other point is this.
It is because every time it's held up. Original side matters we will not be able to take.
Order, this marketing order is notified in amplifies the power of control and which order to make this. Next acceptance and it is market controller. At fourth you command I have said so the matter relating to export will be falling in chapter 4 for which there is another provision to make by law under section 49. That section 49 has a code. Section 30 has
Yes.
if they started
Yes.
control over export of tea and tea. Control of tea and export, etc. So this is a export, this is a matter which will be falling on chapter. Then one of the dynastic chapter, which is at sales.
Yes.
Control by central government. Section 30. Power to control price and distribution of POP banks. That is the very the power is. I read it 5, and I stated that this is not possible. So this is beyond the confidence. Beyond the confidence of the authority because of the part which was dedicated and therefore it is directed and because it was that there was a system I asked there was no repression in practicing that it is from the so it is really not that I and my point was this similarly that this is all the and outside of chapter 4. All other provisions, etc., will also be back in because it is outside. Whatever provisions which are outside chapter 4, for which there is already came another other which is section 49, so thank you, page 35. Power of the central government to make rules. Here, there is power for centrally export, etc., all are distributed. But this power is not
Very well.
We all know that Ganga clause is there. There is a provision like this that the table and all 90% time we have for those and something which is required not actually in that way that but there is the provision that is there is an only any action such kind of people talking because in that phase of the chat they were interested in that it's very actually 7 on the ground committed by other somewhere but all things have been done and make out the whole solution road and tender is not approved by one person and all things have been done. Then one can apply to the study. There is a clause. They know that there is no application. Those being done for business. Here, it is for doing a what I can say, doing all but in my personal thoughts, it doesn't look like I write my concern will go take steps. It won't be clear what should be tests. I can ask that we make this action of one person and go by other 10 years nothing has been done. Under the covered question, no concern is just for most people by India government. So what is the intended in exactly federal service? In that case, and that pencil is not marble at all. It starts into the they said many times that all others are compliant. In the application, no document that you have, that any business that is from that and it's a multi it can't go they were giving because no one. It can't be done. It will be a good future. It might be the origin, it will be this different circumstance. And my this should be another one on this better if I do. But if I am put a declaration that multi-origin, my should be another one on this better. Then you know that which order
This case you have made out in the writ petition.
I have known that this operate by all the agencies and it is not a good fear. Which is not the
No, that if you use multi-origin, then in that case the goods will be confiscated in the case. But those are not part of record. So that is a submission. How will the court ascertain this as a factual issue? No, now demonstrating in reply won't do because they have not been able to meet it. But that should have been tested only if it was part of the affidavit. Whether it is there in customs or not, I don't know. That is why this submission was required to be there on affidavit so that it could be dealt with. Because this is now unilateral. The court cannot deal with your submission. It has to be dealt with by the other side. I can decide whether the dealing is right or wrong. I cannot deal with it. Very well. How long will you take now? Because it's almost because no, I'll do this. I'll fix it on another day because I cannot hold on to this original site. So many people are waiting also. Let us come back. Yes, what was your submission? Why do you want to be added in their writ petition unnecessary?
Well, I'm the Tea Association of India.
Yes.
The tea producers are my members. Now, my lord, what has happened is this directive or notification, whatever be
You
the
take 2 minutes, 54.
2 minutes, lordship.
At 56, I'll stop.
I will stop, lordship. The tea producers are the beneficiaries of this notification. What we came to know of, in other words, our members informed us, is that a writ petition has been filed in this case, challenging this so-called directive or notification. Now, my lord, it is in the interest of my members that this directive was issued. Therefore, my lord, my most humbly submitting that we should have been made a party by default because we are the direct beneficiaries. Any order passed, this notification would be impacting us, no one else. First and foremost, the tea producers. Because there are tea producers who produce authentic Indian teas, they are sending Indian origin teas. There are other exporters who are mixing it with cheap quality imported tea and passing it off as Indian origin tea. That is the mischief which was sought to be cured through this directive. Now, my lord, all that we want is we do not want to file lengthy pleadings or anything. If lordship is kindly pleased to add us as a party, we'll simply give us any 10 minutes on any date lordship's convenience. We'll simply make oral submissions and thereafter file a note. And that is all that we ask for. We'll make it very short. In fact, we'll try and once we file the notes, we'll circulate it to the petitioners and the tea board so that if at all they want to make any submissions in respect of that, they can. We do not want to hold up the proceedings. But most
You
of
have served a copy of your application of
Lordship,
Mr.
we
Mehta.
have. It's been served.
Mr. Mehta, what is your response? They are necessary or they are not necessary? They are not proper. Why? Proper. Will they be affected by any order passed by it? Suppose I set aside the notification. Will they not be affected then? Very well. That is for the court to decide ultimately upon hearing parties who will be affected.
They are now, they are. That's for the for the purpose of educating the.
Very well. We'll have to hear it. I'm not adding them now. We'll hear it.
Lordship.
Heard Mr. Mehta, learned advocate, learned senior advocate, appearing for the petitioner in reply. Full stop. He has not yet concluded. Full stop. Very good.
Well, it is IAGA number 1 of 2025. 2025. IAGA 1.
They are harvesting this benefit out of it.
Well, that is exactly this notification is for my benefit, which is why if it is squashed, I am the one affected.
GA 1 of 2025 has been filed by
of India.
By the Tea Association of India, seeking to be added as party to
What you will kindly take up paragraph 25. Yes. In the said case, after referring to civil procedure code by Mullah, this court in Renuzevi, while drawing a distinction between the preliminary and the final decree, has stated that a preliminary decree declares the right or shares of the parties to the partition. Once the shares have been declared, and a further inquiry still remains to be done for actually partitioning the property, placing the parties in separate possession of the divided property, then such inquiry shall be held, and pursuant to the result of further inquiry, a final decree shall be passed. A preliminary decree is one which declares the rights and liabilities of the parties, leaving the actual result to be worked out in further proceedings. Then, as a result of the further inquiries conducted pursuant to the preliminary decree, rights of the parties are finally determined, and a decree is passed in accordance with such determination, which is the final decree. Thus, fundamentally, the distinction between preliminary and final decree is that a preliminary decree merely declares the rights and shares of the parties and leaves room for some further inquiry to be held and conducted pursuant to the directions passed in the preliminary decree, with inquiry having been conducted and the rights of the parties finally determined, a decree incorporating such determination needs to be drawn up, which is the final decree. Then, applying the principle laid down in the aforesaid authority, it is graphically clear that in the case at hand, the parties entered into a compromise and clearly admitted that they were in separate and exclusive possession of the property, and the same had already been allotted to them. It was also admitted that they were in possession of their respective shares, and therefore no final decree or execution was required to be filed. It is demonstrable that the compromise application does not contain any clause regarding the future course of action. The parties were absolutely conscious, and rightly so, that their rights had been fructified and their possession had been exclusively determined. They were well aware that the decree was final in nature, as their shares were allotted and nothing remained to be done by metes and bounds. Their rights had attained finality, and no further inquiry from any spectrum was required to be carried out. The whole thing had been embodied in the decree passed on foundation of compromise. It is to be borne in mind that the term compromise essentially means settlement of differences by mutual consent. In such process, the adversarial claims come to rest. The cabin between the parties is given a decent burial. A compromise which is arrived at by the parties puts an end to the litigative battle. Sometimes the parties feel that it is an unfortunate bitter struggle and allow good sense to prevail to resolve the dispute. In certain cases, the intervention of well-wishers, conciliatory process commences. A reciprocal settlement with a clear mind is regarded as noble. Then, Lord, next paragraph. In the present case, as the factual matrix would reveal, a decree came to be passed on the bedrock of a compromise in entirety from all angles, leaving nothing to be done in future. Curtains were really drawn, and the court gave the stamp of approval to the same. Thus, the inescapable conclusion is that the compromise decree was the final decree. Presently, we shall dwell upon the issue whether the execution levied by the respondent was barred by limitation or not. The court, by its order dated so accepted the plea of the present appellants and came to hold that the execution petition filed by the decree holder was hopelessly barred by limitation. Then, I'm skipping some paragraph. Kindly comes to paragraph 36. From 34 onwards, my lord. (32) is also kindly come to 32 first, my lord. It is well settled in law 32 that a preliminary decree declares the rights and liabilities, but in a given case, a decree may be both preliminary and final, and that apart, a decree may be partly preliminary and partly final. It has been held that it is worth noting that what is executable is the final decree and not a preliminary decree, unless and until the final decree is a part of the preliminary decree. That about the final decree proceeding may be initiated at any point of time. So, final decree is executable. Then 34, regard being had to the aforesaid principles and having opined that the decree passed on the basis of a compromise in the case at hand is a final decree, it is to be addressed whether the execution is barred by limitation. Then 35, the limitation article is placed. 36. In Chiranjit Lal, the question arose whether a final decree becomes enforceable only when it is engrossed on the stamp paper. The judge bench dealing with the controversy had opined that Article 136 of the Limitation Act presupposes two conditions for execution of the decree. Firstly, the judgment has to be converted into a decree, and secondly, the decree should be enforceable. Submission that the period of limitation begins to run from the date when the decree becomes enforceable. That is when the decree is engrossed on stamp paper is unacceptable. So court will not come to the finding that on the date the decree is passed, it becomes enforceable from that moment. So not taking the benefit of this judgment note, I humbly submit that firstly, from the nature of the decree, it is to be seen whether the shares of the parties is finally ascertained and the mode of partition is also finally ascertained, leaving no scope for further inquiry. That is one. And on the date it is passed, it becomes executable. Now the parties, they might be in separate possession, they might go for separate possession, they may for the partition by brick wall, or they do it by some other means for separate possession, that is up to them. But it becomes partible if a party doesn't adhere to the decree, the other party has a right to get it executed. So it is by nature a final decree. So Article 45 is attractive. That is my humble thought.
It is in the context of a compromise decree, but the passages you see there are generally nature. It shows what is a preliminary decree, what is a final decree, and what are the attributes of a final decree. That is what submission is. Execution is something else. Exigibility to stamp duty is not dependent on the executability of the decree. The decree may or may not be executable, but once it takes the final shape, in the sense that it determines the shares and rights of the parties, the moment it does that, it becomes exigible to stamp duty is the submission of Mr. Banerjee. And that is what the a reading of this judgment also is. Let us assume I'll extend it a little further. Suppose A sells a plot of land to B. There is a conveyance. Irrespective of whether the B is given possession of the land or not, whether stamp duty will be leviable on the conveyance or not. It is as simple as that. So this is also the same thing, because your right is crystallized in respect of the immovable property. It's that exactly that. No, if you read this section, this also makes the same thing clear. See section 215. Please read to see what is an instrument of partition. What is it? Instrument whereby, yes, please read. Yes, please stop here. They either divide or they agree to divide. So even if there is an agreement to divide, that would qualify for an instrument of partition. Similarly, if there is a decree which determines the right, but in terms of the determination of the right, physical partition of the property has not been done, would not disqualify the decree from being considered as an instrument of partition. That is the substance. Yes. Order for effecting, not an order which has been executed and partition done. In execution of the order, there is a difference. There is an order for effecting. Not required also. The moment the order says that this is the decree and these are the shares, it is an order for effecting partition. It is an order for effecting partition. Demarcation is execution part. Demarcation is execution. So to the stage of execution, that doesn't say that it has to be effected. It says that the order should be, you go and effect partition. That is it. The moment the order says that, it calls. That's the finding of the interest. Executability of the final decree is that is a different thing. But executability of the final decree is not something which is going to affect exigibility of the decree to stamp. It will become exigible to stamp the moment rights are determined. Because if that had not been the case, then in that case, an agreement to divide would also not have been exigible to stamp duty. Not required. Not required. But for the purpose of instrument of partition. And Mr. Banerjee, there is no new creation of right here, or there is a new creation of right? Right.
No, Lord, that judgment your lordship referred to me, Lord, that was
that was in the context of a compromise. But even otherwise,
it is not an absolute proposition of law that only when there is a creation of rights, it becomes amenable to stamp. That is not the law. The moment the instruments mentioned in Schedule 1A are executed in West Bengal, they become accessible to stamp. If your lordship can you see section 3 once, my lord? Yes, yes. I've placed that.
Section 3.
If your lordship kindly come to section 3.1.
Yes, 3.
3 is not original part, is not instrument chargeable with duty, subject to provisions of this act and the exemptions contained in Schedule 1. Following instruments shall be chargeable with duty of the amount indicated in that schedule as the proper duty therefore, respectively. That is to say, then A, B, C, 3 kinds of instruments are provided. I am not reading because in West Bengal these are not applicable. The amendment applies. Now your lordship will kindly come to the amendment. West Bengal amendment. A proviso is added. The following proviso shall be added. Provided also that except as otherwise expressly provided in this act, and notwithstanding anything contained in clause A, B, or C of this section, or in Schedule 1, the amount indicated in Schedule 1A to this act shall, subject to the exemptions contained in that schedule, be duty chargeable under this act on the following instruments mentioned in clauses AA and BB of this proviso as the proper duty therefore, respectively. Every instrument mentioned in Schedule 1A as chargeable with duty under that schedule, which not having been previously executed by any person, is executed in Bengal on or after the first date of April 1923. The moment that instrument is executed, it becomes chargeable. For that, creation is not a mandatory requirement, creation of a new right, because not an affidavit. An affidavit is a declaration. That also requires stamp, rupees 10.
But I think there are judgments, not only this judgment, there are earlier judgments.
Reading of the section is a fiscal statute.
Which have differentiate. No, in the context of this one, it is in the context of fiscal statute only because there has to be some basis. The concept of levying stamp duty is based on transfer. There has to be an incidence of transfer. Merely because I arrange my own affairs and my rights are not transferred to somebody else, that will not incur stamp duty on me.
Now, my lord, suppose not an agreement to sell. There is no creation of right. Only a promise.
Agreement to sell is not mandatorily
stampable.
Stampable it is, but it is not mandatory because it may or may not. That is why it is not mandatory.
No, if it is not stamped, then the effects of
admissibility.
That is different.
That is different.
He may choose not to stamp it. Nobody will force him to stamp it. But if he wants to rely upon it, then the consequence will come. Will similar Schedule 1A, then most of the entries will go. we only will apply rigorously the principle that new right has to be created, so most of the entries will go. What we will see about adoption D. Affidavit. 4 is affidavit. Affidavit will there is no creation of right. Then these entries will go. Then he will have to challenge entry 45. That means there is no creation of right, it is not chargeable. I only have to show that it is an instrument executed in Bengal after 1922 and it is not executed for the and it is coming within one of the entries. That is what the authority will see. Then he would not have presented it. Not if it was not required to be stamped, he would not have.
Subsection
215.
215. Yes.
Same thing.
No, Mr. Banerjee, it may not be the same thing in the facts of this case. For effecting partition, where is that final order?
For effecting,
where is that final order?
No. So it is part of the supplementary affidavit. To see the supplementary affidavit.
No, the final decree is this. Final decree is at page 88, 89, 90, 91.
Kindly comes to paragraph 9 onward.
Yes. See paragraph 11.
In view of the above, final decree is passed by declaring that the defendant number 3 is entitled
It stops at that. This says final order for effecting partition. Partition to be effected, where is that?
Can you kindly come to the next page,
Next page is this full.
By making the proposed plan for partition, being annexed L. To the
That is only proposition. There is no direction to that effect as yet. There has to be an order for effecting partition. If fiscal statute, again, your this interpretation has to be then strict. It has to be an order directing partition, effecting partition, order for effecting partition. That is not there.
If that is their argument, my lordship will kindly see. It is an inclusive definition so far as the second part is concerned. The first part is instrument of partition means any instrument whereby co-owners of any property divide or agree to divide such property in severalty. So
they could have that
if,
also.
I'll argue the second.
There is a counter to that. If they had thought it fit to clarify it for the purpose of instrument of partition in the case of an agreement to divide or agreement of division by the co-owners, and they did not make the same distinction in an order, that means the legislature wanted to differentiate between two kinds of orders, where there is an order only simply declaring it. They contemplated this kind of a situation. There can be a situation where partition may not be directed to be effected, only shares have to be declared. That can also be a situation.
First part is below 215. First part says below any instrument.
Yes, that is different.
That is so that is not the.
Therefore, the moment you say includes, when you specify the orders of a civil court, then the legislative intent as regards orders of the civil court have to be confined to the words used by the legislature. I cannot insert such words which have not been used by the legislature for such purpose. It will no longer be a part of the general expression instrument, because this has been specifically mentioned. That is one of the rules of interpretation which we apply.
It does not say you partition.
Yes, that is what the language is, because you see the amendment, prior to the amendment, it said directing partition. Then it said order effecting partition. It is becoming more specific on that the order should direct that there has to be a partition. It is only then that it will be considered.
Kindly consider, can that be not done? It's not the first part, which is the genus, includes every instrument. Now partition decree.
But when you include the instrument,
even in that case,
then Mr. Banerjee, the argument would be that the expression will include only such decrees which direct or which pass an order effecting partition. Other decrees of partition may not be. There may be a final decree of partition of this nature also, which is not, the word, which is not a decree for effecting partition. So this will definitely not be included because it is inclusive. So it includes only such decrees or orders which are orders for effecting partition. So an order which is not an order or a decree which is not a decree.
Instead of also. Includes also a final order.
Yes.
So it is not a final order. Also, then the fiscal statute has to be read as it is.
Yes,
as not interpret
as it is.
So if inclusion part goes, then also the first part will come.
The first part will not come because this has been specifically mentioned. First part will not come because this has again been clarified in the schedule.
Includes also final order.
Schedule instrument of partition has again been defined in the schedule that you said, schedule 1A. There again they have said the same thing.
Schedule
1A you just now referred to?
1A, yes.
Entry 45.
Entry 45. Instrument as defined by section 215.
Yes. Then C, where a final order for effecting a partition passed by revenue authority or any civil court for effecting a partition. So if there is no final order, so this refines the legislative intent all the more. Then there is no stamp duty prescribed for any other type of an order.
No, here there was no direction because parties accepted the plan. Kindly see. Kindly come to paragraph 10. The defendant number 3 had submitted the copy of the conveyance deed dated 5th August. Parties have accepted the plan for proposed partition submitted by partition commissioner.
We will not go behind the order now.
No, so I'm on the order. I'm on the order. So paragraph 10.
Why this order was passed? Why this order was passed is going behind the order. Why this order was passed?
I'm only reading.
The moment we say why this was passed, because parties accepted or because parties did not accept what crossed the minds of the learned judge, we are not going to prove that.
Then the judgment where there was a compromise for partition. Court has said that parties have compromised, so no necessity for meets and bounds. That is a compromise. Then in compromise there shall be no further direction. But the court held it to be a final decree.
Which is why then that logic may apply. Yes, final decree, there is no doubt about it. But whether it is a final decree of such nature which will fall within the scope of section 215 and entry 45 of schedule 1A is the question.
Lord, if it is a final decree, Lordship is considering it to be a final decree. In that event, Lord, can it be taken out of the scope of 215?
It appears to be because section 215, even if I bring it within the scope of section
in my humble submission, also the word also, Lord,
because Mr. Banerjee, that is again negated by the schedule prescribed in the Act, where it specifies that this is the decree. Otherwise, other decrees would have been mentioned, and for that separate rate would have been prescribed. That is put behind. That is put outside the scope.
Inclusive definition cannot be read as exhaustive. So it includes the final decree. So there might be a case where there is a final decree.
Final decree. That does not mean that it will include decrees apart from that.
A final decree, my lord, doesn't directing partition. Specific direction for partition because
it does not agree. At the moment, prima facie, it does not appear that it will include a decree not directing partition, because this becomes absolutely, diametrically opposite to what has been specifically by the legislation.
Since it is the word also is used, it cannot be construed
even
that the part only means partition decree where partition is.
That should be
had the word been only and includes only a final order for effecting, then my lord, it would have been restricted so far as the final decree is concerned. But
let us come back on this.
Includes also.
Let us come back on this. I don't think this is going to resolve like this. Some more authorities might be needed.
Because that concept of transfer of right, that I have satisfied lordship. From the entries also.
Maybe I'll have to do my own research because I have it at the back of my mind. I have read it and I have read it thoroughly. It was there some time back, not now. But I have read it.
Stamping, my lord, for stamping.
No, there is a logic. There is a sound logic by the Honorable Supreme Court itself, I'll also come with my own research.
Mine.
Very well.
Possibly the judgment will not cover this eventuality, where
Yes,
there is no partition, but because of compromise, parties have.
There is another instructive judgment of Justice Ravindran, where he has elaborated on what preliminary decree means,
I'll do
what
some more.
final decree means.
I'll do some more.
In mortgage suits also, how this principle applies. There is an elaborate discussion at Justice Ravindran.
Right. His judgments are
Yes, mathematically.
Mostly in arbitration matters, but in other branches.
Every branch. Heard Mr. Dan, learned advocate appearing for the petitioners, and Mr. Banerjee, learned advocate appearing for the respondents. When can we take it? What is the matter?
Amendment was just started. Other proposal has been made. And saying that the amendment is not decided.
Yes, Mr. Dey. So cause under challenge. Why you have kept the amendment pending and issued so cause?
I say, or in this petition, they have challenged the show cause notice.
Right. But their grievance is that the show cause may not have been issued because he wants certain amendments of shipping bills. If the shipping bills had been amended, the reason for you to issue show cause may not have been there. So if the show cause exists on a basis which could have been knocked off by an act of yours itself, then issuance of show cause may be questioned.
These are the points they can take up this point before the show cause issuing authority when the adjudication is going on. They have not replied to the reply. They can face the adjudication process itself and they can take up all these points before the authority concerned.
Yes, ma'am. Why do you say that the show cause notice is without jurisdiction?
Under section 149 who is supposed to decide my application? First, regulation relies upon my decided my making the application. I made the application within time 1 year. My application was kept pending in 2020. Then I told them that I've already made this application. They were silent. In 2025, that application can make this, which are submitted, does not show the receipt, but they don't deny the application. And your notice, they are proceeding with the court order as if I have not fulfilled the export obligation. So I will take 10 minutes.
Yes, please. Let us proceed for 5 minutes. Let's see what happens. Yes.
So please.
Page 40. Page 40.
Authorization. I have to make a report. Make an import using free.
After a bad news. Yes. No.
Under this advanced authorization license server. Under this license, I am allowed to use import using free for the purpose of export. I am a manufacturer exporter. Find exporter status, exporter type manufacturer exporter. The serial number 5. Exporter type manufacturer exporter.
Yes.
Your first matter to do with PPM. It's important and it is blended with local. And your
Yes.
Follow your validity of authorization.
Yes.
I have to make import within 2019-2020, which I have done. Then you're looking previous shipment, export obligation, 18 months. I have done that. You'll also prepare a cost list of date. This for convenience. You're also this this was
Once we learn it, then yes.
you're also issued on 29th March 2019. You're also by Director General of Audit. According to this script, I was supposed to make import by 29 March 2020. I made it within 19 within time. Then you're going to put the blend sheet and declaration DEC that I have blended is their custom seal which shows that I have blended the goods. And next you'll also make the export within time 29 and 30th of December 2019. The process secretary will fulfill the export obligation in time. Under this certificate and exported. You're also as per the RBI guideline have to get foreign remittance within 9 months. That also has happened a lot. 10th February and 22nd February. On 20th February 2020, I write to BBS. This is as well as point number 5.
Page 41.
Authorization issuing office within 2 months from the date of expiry of the export obligation stated above, document as prescribed under paragraph 4.44 and 4.42. As evidence of towards the end of the sentence, right? As evidence of completion of export obligation. Within 2 months, I am supposed to inform them that I fulfill the obligation. That is done or not. I think 84 important documents on 26th August.
Yes.
Previously, I have reported under the I have from this document that 84, it is evident that contemporaneous intention to avail the benefit of the you also have rely on one judgment where court has where Honorable Supreme Court held that since the particular evidence with intention, with inception to avail the benefit of the plea, correction should be allowed. You know, lot of times, placing that your one paragraph is there. In the practice circumstances of the present, you have considering and right from the beginning. The respondent has declared the intention to claim the reward under the scheme. This is a different similar. It was found that there was an inadvertent mistake checking the column end into the bar.
What is this EODC? What is the full form of
I have asked, after fulfilling the export obligation, I submit all documents and ask for export obligation discharge certificate. Now, later we are for $92, where the mistake that this DEC number was not mentioned in the shipping bill. This was discovered from the document that is
is 93.
In the shipping bill, the reference number is invisible. Details of the reference number has been there in the shipping bill. This will show that under this T minus 4. That was missing. As come to know from DBS letter, which is the same line. On the same page, you'll also like 130. I inform them to make the correction. You'll also I inform the proper officer under 149, which is at 630.
Yes.
Why? The proper officer will also take a circular. From and he can decide on the issue. The scope of authority cannot do it. So this is the next question. So let's say I just mark for
so-called issuing authority is not the proper officer. And if your amendment is allowed, then in that case, the so-called is only on that ground.
Obligation under this license before execution.
And you had sought for exemption.
And so can start with under the 84, and when the mistake was declared, it is at 9. On the same day assigned to the proper officers at page 113. Now you got the two letters I will show. While you got I will not get justice from them. You got at this fine. It is given as 1st September 2020. The logic I received a comment. In reply to this comment, the logic at page 109. The logic will find that I have written to them. In this letter, I have enclosed this 2020 letter for amendment. At that time, the logic kept silent.
Yes.
At that time, the logic kept silent. Now, please show for this 28 April 2025. For the first time after 5 years, we are saying that this letter does not bear a receipt. However, they don't deny the letter. You'll also I will place the screenshot on the You'll also they are not saying that this letter is not in our report. You'll also notice 175. Point number 2. Also in the letter secret. Have you also found 21/11/2020 because claims on the letter bearing number 12 dated 20/11/2020 in which regard was submitted commissioner report, but you have given submitted for the your office this is neither here nor there. They are not saying that it's not a part of their reports. And your office 22 not say that it is not there. And your office after 5 years they are issuing the letter. Now again they have referred to a regulator tipping this converter in relation to your office at page 175 line. You also mandate that within 1 month. Also, handle out although this later, but since they are denying on their obligation and my obligation was to make an application within 1 year as per this. I have shown that I made application way back in 2020 within 1 year. Now they were supposed to decide in 30%, they have not. And it has to be decided by the doctor.
Is there any admission from them that you had ever applied for because?
Yes, there is one admission.
Okay.
Page 149. A letter was written to me where they said that out of the 2 shipping bills, they are putting one for amendment. And what should be there for amendment?
So this refers to your letter dated 21st of November 2023.
And in 2020, so I ran it for 2020. From the document has been my intention from day 1 is evidence.
So you had claimed exemption in respect of 2 shipping bills.
One is put forward, but in reply to that, you're not pending. 5 years old.
Yes, Mr. De.
In that case, our application for amendment may be taken up along with the state show cause notice. Because in the state show cause notice, they have not replied to the show cause notice, and all the points have been kept open in the show cause. Show cause is only a question from the authority concerned to reply to certain points. Later reply, later, my lord, undergo that exercise. Later reply to those things.
No,
And
but if the contention is that had the amendments been allowed,
but that's why, my lord, I submitted very humbly to your lordship and subject to my lord's kind sanction. The amendment application and the said show cause, let both be taken up.
Why would the show cause exercise then continue till the amendment?
Because
along with the amendment?
the reason is they have not replied to the pre-show cause at stage. Had they given those replies, there would have been
At
no
the
necessity
pre-show
for
cause,
this
you
thing.
did not reply. No, but
That could have been done without prejudice.
That should have been indicated at the pre-show cause stage.
So after this report, no reply has been given. That is the fact.
Very well. Let us meet tomorrow then. I'll record an order because if I start dictating today, it will take lots of time. Hard. Ms. Chaudhary, it will be there as it is. It's open.